Good morning, everybody. Happy Wednesday. Welcome to TCF Live. Nice to have you all here. Let's start our day in Lake County, Ohio. This is Judge O'Donnell.
Probable cause hearing, Your Honor.
Is that what you're going to do?
Yes, Your Honor.
All right. So, why are we here?
Your Honor, I try to be perfect because I got people depending on me.
Well, here, don't try to be perfect. Nobody's perfect, so don't try to be perfect. This isn't a contest of being perfect, okay? You're here on the periphery of this murder that occurred on two F4s, okay? And a lot of it has to do with your good buddy Triplet, okay? That's why you're here. So you're like right on the edge. So I did not send you to prison on these two F4s. I sent you to jail for 180 days to complete the jail treatment program, then to complete the NeoCap program, on the chance that you're going to conduct yourself when you're done as a law-abiding citizen who, I think the first thing out of your mouth is you've got responsibilities. So in order to attend to your responsibilities, you have to conduct yourself as a law-abiding citizen. Yet, within a month, after you're sentenced, you're here for getting in some altercation with other knuckleheads over a goddamn pastry. So explain this to me.
It started off with me having a conversation with Noel, whose big Texas had got took, and he said that he didn't want to shut the pod down. And I explained to him like yo, steps you got to like I shut the pod down, and then
how does one shut the pod down?
Cause not like shut the pod down as in like the CEOs come in and investigate it. We'd be on lockdown. So after that, Eberlin had got into the argument. Like it was an argument, it was a conversation. He had got into it. It was like I'm a punk kid and I'm broke and everything else. And I'm like as I said it don't pertain to you. Just stop talking to me. But this is not the first time that he had came to me with some like some mess basically.
Some what?
Some mess. And then after that it was count time. The CEOs had came through. I laid down, and then me and Noel was talking about cars. We started talking about cars, and then he went back into the conversation saying something else. And then after I told him like you got it, he decided to start screaming. After he started screaming, you can hear me on camera saying like you got it, but just leave me alone. And then that kept going on for like 5 minutes, 10 or so minutes. And then Mac from downstairs had came upstairs and had he was arguing with Eberlin, and Eberlin was like, "Oh, you trying to protect your little buddy?" And then Mac was like, "No, I'm tired of y'all arguing. Both of y'all shut up." And then I laid down, and then him and Mac kept going back and forth. And then that was the night. And then the next morning, woke up and I was in Fort Frank in the hole.
So what exactly did you do wrong in this whole thing?
I could have just walked away from it.
Okay. Why didn't you walk away from it?
Truth be told, I really don't know, but I called myself de-escalating the situation by telling him like you got it. Like instead of me arguing back and forth saying like I got this, I got that, I just said you got it. Like you right, bro, you right, and that's what I'm saying the whole time. And I really don't know why I didn't just lay down and just be quiet and have him talk to himself.
Okay, so who's the bad guy in this whole thing?
Me,
And who else?
Eberlin.
Eberling? Is that the name, Dave?
Yeah.
Eberling. Who's Eberling to you?
Nobody.
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 What do you know about Eberling, Dave?
So he is on probation through Judge Rupel's court for tampering with evidence and theft, F5. Looks like he got booted out of JTP too.
Okay. How many people are in the jail? Do you have any idea?
No.
How many people are in the jail treatment program that you were in?
I believe 15 or 20 or so people.
Okay. Out of those 15, or let's say 20, what percentage of those members of the jail treatment program are have demonstrated to the rest of society that they're a pain in the ass?
I don't know, Your Honor.
100%. Okay, that's my guess. So they wouldn't be in the jail tree. You've been a pain in the ass of society. Okay. So should we continue to try to make you not be a pain in the ass to society, and to conduct yourself as a law-abiding citizen, or should we just abandon that project and send you to prison? What should we do with you?
Definitely don't abandon me, but help me to get on the path of growth and be a law-abiding citizen.
All right, I can help you in any number of ways. But if you continue to be a pain in the ass, it doesn't matter what I do. Doesn't matter what Ms. Hibbard does. Doesn't matter what anybody does. So, like I said earlier, you have 2 F4s because you are on the periphery of this Willoughby murder. And you were given a chance, and you decided to get in some argument with Eberling, who means nothing to you. Now, if you end up a prison inmate, then you're probably going to need to have those arguments and those confrontations and physical fights for every day that you're there. That becomes a necessity. Did you actually engage in a physical fight that resulted in you being put in a hole?
No, it was horse playing with Sullivan.
I don't know what horse playing is.
It was us wrestling,
Okay.
but it was no physical fight.
Who was the referee for the wrestling match?
There was no referee.
Okay.
It was really no referee. It was just us playing around.
All right. Well, you shouldn't do that, okay? Because here's the consequence of that. So, I'm going to think about what I'm going to do with you. And you're going to come back here in about 2 weeks. Ms. Hibbard, you can go get a date from Maria.
Understood, Your Honor.
And for the final hearing. And then I'm going to decide what I'm going to do with you.
All rise.
Well, there you go. That's a good way to start a Wednesday. Good morning, everybody. It's TCF Live. The more we watch Judge O'Donnell, the more I like him and his plain spokenness. You've been a pain in the ass to society. What am I going to do with you? So many judges could say that exact same thing about so many people. Let's move up to Michigan. We'll say good morning to Judge Dad.
Walk away, and then that you resisted and obstructed an officer by failing to comply with lawful commands. This is, both are misdemeanors, punishable by up to 500 fines, 90 days jail, costs for all of those penalties. Do you understand that? Did you sign the advice or rights form here today, and did you read it and understand it?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial then. Do you understand that?
Yes, sir.
All right, you still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea on both cases. I'm giving you a $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal controlled substances. You cannot purchase, possess, or consume any one of those. And also, no contact with prosecution witnesses except through your lawyer. I'm sorry, yeah, except through your lawyer if you ever get one. Do you understand that?
What's that on the other side?
It means you can't have contact with prosecution witnesses, but if you have any of their witnesses,
Oh,
I mean, it could be neighbors, you can't have any contact with them. I don't know where you live, I don't want to know, but you can't have any contact with anybody who they may call, that was on the scene watching what happened. Do you understand that?
yes.
Well, you're, okay, do you? You're looking at me like you
I mean,
don't.
like, do you mean like the police were on the scene watching what happened? Or
You-
like a?
I don't know who was there. I don't want to know. I don't even want to know if you were there. I'm going to assume you weren't there. Listen to me. But if there's any witness for the prosecution, you can't personally have contact with them, whether it's a police officer or a neighbor or whoever else heard this.
Okay.
Okay?
Yes.
I'm entering a not guilty plea. I'm sending you to the prosecutor. We will go from there. Okay?
Yes.
You're gonna go out in the hall and sign in next to Brownstown. And they'll call you in and speak to you about it. And then either way, you're coming back in front of me. Thanks. Mark Brom.
Thank you.
Mark Brom, 25B148535A. Which one do you have, Mr. Bulahanis? I don't even,
Your Honor, I have Clayton Burgee and Evan Harato.
okay.
And I've seen the prosecutor already, and we're ready on both of those if the file makes it to the court.
Okay. Okay, thanks. I'll be right with you. Mr. Brom, your name?
Mark Brown.
All right, so this is simply an early discharge. John, call Brownstown in here, will you, 249? Give me 1 second. So you're trying to be discharged in half the time, you filed a petition, and I'm gonna call in the prosecutor. Says you've done everything, so there shouldn't be a problem. Just grant me. Give me 1 second. Good morning.
Hey, Judge.
Your appearance?
Caitlin Fuller Carter, the Dressman Township.
I placed this defendant on probation. It was leaving the scene of a property damage accident for 9 months. Mark Brom's his name. He's done everything. It looks like they emailed you on the 10th. Do you have any objection to early discharge?
No.
All right, so by law, you're entitled to that, sir. I'm going to go ahead and grant your request for early discharge. You are all set. You're off probation. We'll send you the paperwork, okay?
Thank you very much.
Best of luck to you.
Thank you, Judge.
Thank you. Evan Samuel Hurtado, 26W84125 A, B, and C.
1 second, Your Honor. You can get him in the. Mr. Hurtado? Come on in. You're sit like that, please. Good morning, Your Honor. Greg Bulahanis, P36431, on behalf of Evan Hurtado.
Mr. Hurtado, your name, sir?
I've been Hurtado.
Yeah.
Okay, he's got a charge of OWI, he's got an MIP civil infraction and possession of tobacco. Today is the date scheduled for arraignment.
Yes, Your Honor. We waive the reading of the complaint, stand mute, enter a not guilty plea. We just need further discussions with the prosecutor. We're just asking for a pretrial date, and I think it'll be resolved at that pretrial date, Your Honor.
All right, I'm gonna enter a not guilty plea for you, sir. I'm going to give you a $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol. You're not to purchase, possess, or consume alcohol, marijuana, or illegal controlled substances, or you're not to purchase, possess, or consume tobacco products of any kind. Also, again, you cannot leave the state, cannot violate a law, and you must appear in court as directed. I'm going to give you a pretrial date. Heather, what do you have for me?
March 18th at 9:15.
Oh,
Good day,
Yeah.
Mr.
1 second, Your Honor. I'm sorry, 1 second. I get it here, March. Did you say March 18th?
Yes, at 9:15.
Okay, 1 second. Could we do it a little bit later? I have a PCC hearing at 9 a.m. in Dearborn Heights.
Is that in person?
It's by Zoom.
You want to do 10:15?
Yeah, 10:15 would be great, Your Honor.
10:15 will make it, Heather, okay?
Okay.
You're all set, sir. We'll see you here on that date. Thank you very much. Berge.
Thank you.
Clayton Curtis Berge, 26W8412243, A, B, and C.
I'll be I'll bring him right in, Your Honor.
Take your time.
Mr. Berge? I'll be right out from.
Take your time.
Okay, Your Honor. Greg Boulahanis, P36431, on behalf of Clayton Berge, Your Honor.
Sir, your name?
Clayton Berge?
All right, so for purposes of arraignment, he is charged with super drunk MIP and possession of tobacco.
I'm sorry, go ahead.
That's all right, go ahead.
We waive the reading of the complaint. My client stands mute. We'd ask the court to enter a not guilty plea for purposes of the arraignment, Your Honor, and we have resolved this matter.
All right, so this will now result, I'm entering a not guilty plea. This is now going to be a plea to operating while visibly impaired. And he's also going to plead responsible to minor in possession. And it looks like the tobacco charge will be dismissed, the super drunk will be dismissed, and there's agreed upon cost of recovery of $150. Is all of that true?
Yes, Your Honor.
Sir, if you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs, or all those. 4 points would be added to your traffic record. Your license would be suspended or revoked in accordance with your record, and your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that?
Yes.
I didn't hear a word you said. You got to go a lot louder than that.
Yes.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You do not have to say anything. If you plead guilty, you're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving your right to a trial of any kind. At that trial, you're waiving your right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. Again, by pleading guilty, you're giving up your right to a trial of any kind. You understand that?
Yes.
You still wish to plead guilty
Yes.
to the charge operating while impaired? How do you plead?
Guilty.
To the charge of minor in possession, responsible or not responsible?
Responsible.
Were you operating a motor vehicle on January 23 of 26 on Freeland near Reek and Woodhaven?
Yes.
And prior to that, did you drink alcohol? And if so, what did you drink? And how much did you drink?
Yes, I drank. It was vodka, 6 to 7 shots.
What else?
Just vodka.
Were you hand pouring these so-called shots, or did you drink out of a bottle or what?
Hand pouring.
Yes,
You
Your
weren't
Honor,
pouring
so
them
do not-
into a shot glass, were you, sir?
No.
You were just hand pouring them into a cup?
Yes.
And was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
Yes.
In what way?
Probably unable to stay in the lane.
Okay, so you were swerving, going in and out of your lane of travel?
Yes.
You think you were doing that at least in part because of your alcohol consumption?
Yes.
And did he took a breath intoxilizer test at the station, and were the results, do you so stipulate, of
We stipulate,
0.259?
yes, 2.241 and 0.259, yes.
Are you on probation or parole?
No.
Anybody forced you to plead guilty?
No.
You're 20 now, right?
Yes.
I'll accept your plea to operating while impaired. I find it to be an accurate plea. I'm also accepting your, and made voluntarily and understandingly, I'm also accepting your plea to MIP. And I'm dismissing pursuant to stipulation the possession of tobacco charge. That's really high.
Your Honor,
That is really high for a kid that can't drink yet. You're not legally entitled to drink. We got a problem. You better make this bond argument good. I'm not talking about cash. He's going to be getting a sober link by the end of the day. What do you want to say?
yes, Your Honor, he has been attending AA twice a week. I've seen his AA attendance sheet. Got 4 meetings in, and he made a very bad decision on this day. He has a very, very good job. He's works on the wind turbines, makes very, very good money. He made a horrible decision this day, and he has been abstaining since the date of this incident, Your Honor. He is seeing a therapist. He lives about an hour and a half away from here. He lives in the tip of the thumb, correct?
Yes.
And so he's seeing a therapist. He said he's had 3 meetings with a therapist, and he's signed a release of medical records. So they're supposed to be providing me in the court with a copy of his progress. I don't know who the therapist is.
It scares me, Mr. Berge. I hope it scares you.
Yeah, it does.
Can I tell you something, young man? And when I see somebody who isn't legally able to drink with this kind of breathalyzer, the odds of them coming back to a courthouse and something drug or alcohol related are like exponentially high. Exponentially high. I mean, if you're drinking like that at 20, you're going to be drinking until you're, this is bad. Here's what I'm doing. $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. You're to attend AA at least 4 times a week, and that is to be in person. Every time you go, you have to have your form signed. Every time you come to court, you have to bring the form with you. Every time you come to any court proceeding, whether it's here or at your lawyer's office on Zoom, you have to have that form with you. You are to be on a SoberLink device by the end of the day. I'm ordering, and that's a machine that you're going to blow into. I'm ordering a screening and assessment. Heather, call over to probation, please. See how they want to handle this. They could do the screening and assessment, I suppose, by Zoom, and then they could instruct him as to where he has to go to get the SoberLink device. I'm going to defer the sentencing on the MIP. I will, like I said, I'm dismissing the possession of tobacco, no alcohol, no marijuana, no illegal drugs, no tobacco of any kind, no tobacco products of any kind. Again, AA 4 times a week. SoberLink device by end of the day. You cannot leave the state without consent or violate a law. You must appear in court as directed. We're going to give you, I'm going to order a screening and assessment, and I'll give you a sentence date. We could probably do that same day.
That same day is fine as long as it's, a little bit later than 10:15, Your Honor. They can both be set for 10:15, I guess.
I don't have to do that sentencing the same day. Let me see here. I'm gonna let her tell me what to do. Heather, what do you want me to do on that sentencing date wise? She's probably
Sorry, I am Jessica zooming in to talk to them too, Judge. I was on the phone with her. Do you want it on a Woodhaven day?
It doesn't have to be. We can do, you know what? I would love to do these with retained lawyers on Monday morning, while everybody else is getting ready with landlord, tenant, and civil. So I could do a Monday morning is probably the best.
Look and see what we've got coming up. A couple weeks out, you're off, because they're gonna need time to do the report for the screening and assessment. But then
Yeah,
that puts
so-
us the following week, which would put us the same week that he's doing the other hearing anyhow, so I'm not sure.
You want to do,
9th if that's possible, Your Honor.
I'm not here. I can do this
You wanna do the
16th.
16th?
I can't do the 16th. I got all kinds of.
How about the 23rd?
1 second. I could do the 23rd, but it would have to be around 11.
Are you going to be here? Are you going to be ready at 11? As long as you're going to be ready at 11. Otherwise, I'll give you another date.
Yeah, can we do it via Zoom, Your Honor?
You know what? I can't really do that I don't want to do it that late on a Monday. Give me another
Oh.
date, Heather. Why don't we do the,
Do you wanna just do the 18th then when
Yeah,
he's doing his other one?
yeah, we can do the 18th.
That's fine.
And we'll do this at 10:30.
Okay, Your Honor.
So you guys wait right there, but I want to be clear, you're getting the SoberLink device. I'm not trying to pick on you, Mr. Berge, but this is really scary. If you're not
Crystal-
scared about this, you should be. I'm deferring
Crystal
the
Donald's in
sentence
right now.
on the other case. Thank you.
Your
Thank
Honor,
you. We'll see you guys here
Your
then.
Honor-
Thanks.
may I ask you just one thing, please,
Sure.
regarding the bond? So, where he's at, he was able to find, 2 AA meetings one on Monday, one on Tuesday during the week within a 10 or 15 mile radius from his place. Is there any possibility he can do 2 in person and 2 via Zoom per week? Is that a possibility? Or do you want him to do all 4 in person?
I mean,
I don't know where he's gonna have to
where in the
go.
world is Ovid at?
I'm sorry?
He lives in Ovid, OVID?
Yeah.
I
No,
never heard of it.
I moved up into Thumb. It's called Sebawing.
Well, we need to have a good address for you. Are you living on West High Street?
No, that's my mother's address. I've recently moved.
I'm sorry, Your Honor. Here, Your Honor, I got the address. I can,
Go ahead.
it's 352. SEBE.
AING.
Yes, Your Honor.
And is that 10th like a 10 or a TENTH? 10th Street.
The word 10th.
Okay. Okay.
Do you
I'm
need-
writing that on the
zip
file
code,
for
too?
you. No, I can let him do for 2, he's gonna do in person by Zoom 2, but you're gonna have to describe what was talked about. I don't want any names on that. What date you were on Zoom, what time you were on Zoom, what location it was at, and what was talked about. Just a little paragraph, okay?
Yeah, that's usually what I ask them to do, Your Honor.
All right, so that's good enough. We'll see you here on the 18th. Be careful, Mr. Berge. Make sure you get that SoberLink device. You're going to explain that to him too, Jessica. Thank you.
Absolutely.
Yes, Your Honor.
I am.
Well, hopefully he gets that sorted out. A young guy blowing a 259, not good. Let's go back to Judge O'Donnell, new contestant there.
Second, there was a message left for you by probation on October 15th saying you missed your date and needed to appear October 16th by 9 a.m. Failed to report. You understand that charge?
Yes, Your Honor.
Third, submitted a urine sample November 24th, test positive for marijuana. You understand that charge?
Yes, Your Honor.
Mr. Mr. Fatika, as to the final hearing?
Your Honor, we'd like to waive the final hearing, accept responsibility for Mr. Strickland's misconduct, and resolve the violations today.
Is that what you want to do?
Yes, Your Honor.
What's your plea to those allegations?
I'm guilty.
So I'll accept your guilty plea and find you guilty. What in the world seems to be the problem?
I'm going to be completely honest with you.
Try it once, because you haven't been the entire time you've been on probation. Go ahead.
I believe I'm unprobationable, and back in 2023, when I was sentenced to probation, I recall you saying that you thought I wouldn't be able to complete probation, and I believe that to be true. I don't think I will complete probation.
Why not?
I just believe that I'm unprobationable.
What makes somebody unprobationable?
I like smoking weed.
Okay.
I've tried to quit since I was 12 years old. I can't. I've done treatment over and over and over and over.
You can't.
I haven't gotten any different results.
Right. Well, the problem is, it's not that you can't. The problem is that you won't. That's the problem.
Yes, sir.
You don't want to. So am I to assume then, how old are you now?
21.
Am I to assume that when you're 61, you're going to be holed up in some place smoking pot? Is that the assumption?
I'm not sure where I'll be when I'm 61.
Yeah. Well, when you're 25, are you going to be sitting around in a room smoking pot?
No, Your Honor. I'm hoping that I'll have a good paying job and I will be supporting my family.
Okay. Well, how can, you just told me that you can't stop smoking pot. So are you going to find a way to stop smoking pot when you just told me you can't stop smoking pot?
I mean, I believe I can for a certain amount of time, but I always end up not lasting very long.
Did you ever think that maybe you better figure out why that is?
I've tried to figure out why, and I've continued to get the same results. I'll make it a certain amount of time and end up going right back to it.
Okay. Boy, you got a severe lack of understanding of where you're at in your life. Sit down. Mr. Fatika.
Good morning, Your Honor. I think Mr. Strickland, is trying to be candid. I'd like to highlight the fact that he has completed NeoCap, JTP, decision points, and
To what end?
well, he keeps falling back into smoking weed, but again, he's been candid with the court as well as the probation officer. He's been employed. As he said, he's 21 years old. He's been on probation since November of 23. He's paid $930 toward restitution totaling $13,000. We'd ask you to consider all those factors in deciding your sentence.
How many days does he have, Ms. Randazzo?
429 days total, Your Honor.
All right, I've reviewed the pre-sentence report again and the drug and alcohol evaluation. Listen to Mr. Strickland, reviewed the entire record, considered all the provisions in 29, 29, 11, 12, and 13. Well, you have proven your self-fulfilled prophecy has come true. You're not probationable. So I'm going to terminate your community control. I'm going to sentence you to 17 months in prison with credit for 429 days and the costs. When you get out, you might be on post-release control for up to 2 years under the parole authority. If you violate the conditions of post-release control, the parole authority could return you to prison for up to 8.5 months. If your violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months or the time left under post-release control. Anything else, Mr. Fatica?
No, thank you, Your Honor.
Alrighty, friends. Another batch of swift justice from Judge O'Donnell and frank talk, to be honest. Let's do this. Let's go to Florida. Wade Mercer starting his first appearances.
Just a second. Let me take care of Mr. Tice's first appearance. Mr. Tice, your parents? Your dad's in the courtroom, Mr. Tice. You're here because you've been charged with 1 count of domestic battery by strangulation, 1 count of tampering with the victim, and 1 count of criminal mischief between $200 and $1,000. Those first 2 are felony charges. The last one's a misdemeanor charge. Mr. Tice, there is probable cause. That means there's a minimal level of evidence alleged in the complaint. Finding a probable cause doesn't mean you're guilty. It means there's evidence to support the conclusion you may have committed the crime that you've been accused of. So, Mr. Tice, I'm going to listen to the attorneys and I'm going to address your bond or your release status. Mr. Mitchell, anything from the state?
Nothing at this time, Your Honor.
Mr. McDaniel?
Your Honor, just yes, strong local ties. He's born and raised here. He works at Sunland. He has no criminal history that I'm aware of. We just asked asked the court for some kind of reasonable release option.
Okay, so Mr. Tice, the criminal history I've got shows no prior history also. Is that what you've never been arrested or charged with a crime anywhere? Is that correct?
Yes, sir. Never.
Okay. Mr. Tice, the charge you're accused of, the domestic battery by strangulation, is a very serious charge. There was allegedly, you allegedly went in someone's home or your former home, I guess, is what you're accused of. And there was significant physical evidence and blood on you and on the other person, according to the complaint. So I'm not going to give you a conditional release for those kind of allegations, but having no criminal history is certainly going to help. I'm going to set your bond at $2,500 in each of these charges, Mr. Tice, and that's largely because of your lack of criminal history and your employment status. Your total bond is $7,500 cash or surety. Cash or surety means you don't have to come up with all the money. You can go through a bondsman. That's what a surety bond is. So in just a few minutes, you'll get to use the phone. And if you post a bond, you'll be released. If you're not able to post a bond, the public defender's office will be in contact with you at the jail. I am going to ask the jail to give you a notice for your court date in circuit court, and that would be April 7th at 8:30 will be your court date. They'll give you that notice. And let me see if the family has any questions. Sir, do you have any questions? Your dad said he's going to take care of the bond and get you out of there. Now, you do have a condition of no contact with the alleged victim. Just stay away from each other. You don't live in the same residence according to the complaint. Is that accurate?
Yes, sir. We do not.
Okay, so just stay away from that person while this case is pending. I don't want it to get any worse. Any other questions,
Okay.
sir? Mr. Tyson, jail, do you have any questions?
No, sir.
All right, sir. Wish you the best.
Judge, I want to say I glanced at an injunction that might have been filed. I don't know when the hearing is or.
Mr. Tice, come back up just a second.
I don't know if it's deserved.
If there's an injunction pending, I need to make sure that you're aware of that too. So give me a second to look and see if I see one. But I didn't see that mentioned in the complaint. Did you, Mr. Mitchell?
I didn't either. Maybe
I want to say I glanced at it yesterday, or I didn't get a chance. I was doing other stuff working, but I did. I thought I saw one. I could be mistaken.
There was something from yesterday. Let's see what this is.
Yeah, something's open. 2679 DR.
There is a temporary injunction that was signed yesterday. And you have a hearing on that March the 11th at 10 a.m. So in addition to my no contact order on the bond, be aware, it appears that Judge Garcia has signed a temporary injunction. So they will be serving you with that in the very near future and possibly even before you leave the jail. But so there's 2 different judges have ordered you to have no contact. Just be aware of that. And in that case, you do have a hearing, as I mentioned, that's already been set. Mr. Tyson, any questions?
No, sir.
All right, sir. I wish you the best. Anybody else here for a first appearance case? All All right. Next case we have is our interpreter case, Jerry. Well, we got Mr. Cordova. Jerry Aguilar.
Mr. Aguilar?
Were you able to communicate with him, Mr. McDaniel? Or could you talk to him?
Yes, sir.
To anticipate the plea. Mr. Cordova, good morning, sir. Would you please introduce yourself to Mr. Aguilar? Make sure he can hear you.
Good morning, Your Honor. Buenos días, señor Aguilar. Yo soy el intérprete para esta mañana. ¿Usted me puede escuchar bien?
Sí.
Okay, he can hear as well.
Great. Mr. Aguilar, good morning. I'm Wade Mercer, the county judge in Jackson County.
Buenos días, señor Aguilar. Yo soy Wade Mercer. Yo soy el juez del condado de Jackson.
You've been charged with one count of driving with no valid driver's license.
Usted está siendo acusado de un cargo de manejar sin tener licencia válida de conducir.
In addition to that, you have a detainer from the United States Immigration Service.
Adicionalmente, usted tiene un orden de detención de inmigración.
I am going to appoint the public defender's office to represent you in the local driver's license charge.
Le voy a asignar a la oficina del abogado de oficio para la acusación local.
Please listen to your attorney, Mr. McDaniel.
Por favor, escucha a su abogado, el señor McDaniel.
Your Honor, I've spoken to Mr. Aguilar. He's going to plea of no contest to the charges listed.
Su señoría, yo hablé con el señor Aguilar y él va a declararse no me opongo a la acusación que recién se acaba de decir.
Understanding he's going to be sentenced to 2 days in the county jail with credit for 2 days and a $400 fine, which will be a civil judgment.
Él está de acuerdo que va a servir 2 días en la cárcel, pero con crédito de 2 días que ya ha cumplido y va a pagar una multa de $400 que se convierte en un juicio civil.
He's waived his right to a jury trial and call witnesses and understands that any plea can result in deportation.
Él está de acuerdo de renunciar su derecho a llamar a testigos, de tener un juicio, y él entiende de que el acuerdo declaratorio pudiera usarse en su contra en una audiencia de inmigración.
Mr. Aguilar, did you hear that agreement?
Señor Aguilar, ¿usted escuchó ese acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta sobre ese acuerdo?
Ninguna.
None.
Is that the plea that you would like to enter?
¿Ese es el acuerdo que usted le gustaría aceptar?
Sí.
Yes.
And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Y señor Mitchell, ¿está de acuerdo la fiscalía? Sí, su señor.
Mr. Aguilar, I'm going to accept your plea of no contest to the charge of no valid driver's license.
Señor Aguilar, voy a aceptar su declaración de no me opongo a la acusación de manejar sin licencia válida de conducir.
I'm going to withhold adjudication of guilt and sentence you to 2 days in the Jackson County Jail.
Voy a suspender el fallo de culpabilidad y le voy a condenar a 2 días en la cárcel del condado.
Also going to impose the fine of $400, and that'll be a civil judgment against you.
También voy a imponerle la multa de $400 y eso se convierte en un juicio civil en su contra.
And Mr. Aguilar, this sentence is based specifically on your lack of any history as well as the deportation possibility.
Y señor Aguilar, condena se basa en sus antecedentes, no tiene antecedentes penales, y también en posible deportación.
So the Immigration Service should be picking you up within 48 hours, sir.
Entonces, el Departamento de Inmigración posiblemente le va a recoger dentro de los próximos 48 horas.
Do you have any questions?
¿Tiene alguna pregunta?
Ninguna.
None.
Have a good day, sir.
En buen día, señor.
Thank you, Mr. Cordova.
Thank you, Your Honor. Have a good day.
You too, sir. We have Raina Brown next. Ms. Brown, good morning, ma'am. Ms. Brown, you're here because you've been accused of one count of retail theft of $750 or more within 120 days. Ms. Brown, there is probable cause in the complaint. The criminal history I've been provided shows no prior history. Ms. Brown, is that accurate?
Yes, sir.
Perfect. That's great. Ms. Brown, let me see if the attorneys have any additional information they want to make sure I'm aware of. Mr. Mitchell, anything?
We just request the standard no contact with Walmart.
Mr. McDaniel?
Conditional release, Your Honor.
Ms. Brown, given your lack of any history, I'm gonna let you pick between a bond and a conditional release. Some people prefer a bond because it has fewer rules to follow, but it is usually more expensive. If you would like to post the bond based upon your lack of any history, your bond will be $2,500 cash or surety. But I am going to offer you a conditional release for the reasons I've already said. Ms. Brown, you would have the standard conditions of every conditional release, which I'm sure Mr. McDaniel has gone over with you. In addition to that, whether you choose the bond or the release, you will have a condition not to go to any Walmart while this case is pending. You just need to let everything calm down before you go back to any Walmart. Ms. Brown, do you have any questions about that choice, ma'am?
No, sir, I'll take the conditional, please.
All right, Ms. Brown will grant you the conditional release. So what's going to happen, Ms. Brown, is this. Next, the jail's going to let you get dressed in your regular clothes, and they're going to let you use the phone in case you want to call somebody for transportation. Then they're going to bring you to the courthouse where the conditional release office is at. When you get here, you meet with Mr. Goodson, who is the conditional release officer today. Mr. Goodson will go over the release with you. He'll give you a chance to ask any questions, and then you'll be free to go. They'll give you the rules in writing too also. Ms. Brown, lastly, the jail's going to give you a notice for your court date, which should be April the 7th at 8:30 in felony court. That's in the circuit courtroom. And Ms. Brown, usually it's about 30 minutes or so to get you dressed and go through all that and get you to the courthouse. So if you do call friends or family, you can tell them that you can be picked up in roughly a half hour, ma'am, at the courthouse in Mariana. Do you have any questions?
Yeah, I'm sorry. You said I want to do it on a bail bond instead. Is that the same?
No, conditional release and bail bonds are not the same thing. Your bail bond is $2,500, and you don't report to a conditional release officer on a bail bond. You've got to pay a bail bond before you get out of jail and work out an agreement with them. If you want the bond,
Yes,
that's okay too. You prefer the bond?
Yes, sir, please.
Okay, so your bond is $2,500. You still get to use the phone, but you're not released until you post the bond, and you still have the condition to go to no Walmart and still got the same court date. Any questions?
No, sir, that's fine.
All right, ma'am. Wish you the best.
Ma'am, I mean, Your Honor, I don't know if you want to do a cash bond. I asked her and I thought she said she didn't have the money. So would you prefer a cash bond of $250, ma'am, and just post it at the jail? That way the
But I
money
mean-
can go toward fines and costs, and if you're convicted?
Would I be able to get out and go get it?
No, ma'am. Someone's
Okay,
got
I'll just stay with the bail bond then.
Okay.
All right. Wish you the best, ma'am.
Thank you.
Yes, ma'am. We have Jeffrey Robertson next. Mr. Robertson, good morning. Mr. Robertson, you're here because you've been accused of violating the terms of your state supervision. And Judge Garcia, our circuit judge, has issued a no bond warrant. Mr. Robertson, what I'm going to do this morning is I want to get you arraigned because I want to get you a lawyer appointed if that's what you're asking for. Mr. Robertson, would you like to have an attorney appointed to represent you?
Yes.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, please.
Your Honor, we're going to plead not guilty. I set this on April 23rd court docket, and I advised him an attorney to come by and speak to him prior to that court hearing.
April 23rd, Mr. Mitchell, anything?
Nothing from the state, Your Honor.
Mr. Robertson, April 23rd will be your court date. And you'll see. History, and I see 2 prior battery arrests. One of them was adjudication withheld, and one of them appears to have been dismissed. That's all the information I have, ma'am. So let me see what additional information the attorneys have. Then I'm going to address your bond status. Mr. McDaniel or Mr. McDaniel, anything?
Yeah, that's the only thing I'm aware of is that one battery case, Your Honor, that was withheld. We just, based on the complaint, we'd asked for a conditional release, Your Honor, and I've talked to her and she's got us somewhere else to live and there in the Walton County, and she'll stay away from her.
Mr. Mitchell.
No objection to that.
So Ms. Johnson, do you and the alleged victim live together right now?
Yes, sir. We share a child in common.
Okay, so in order for me to grant you a conditional release, there's going to be a condition of no contact, whether you choose the bond
sir.
or the release. But do you have somewhere else you could go on a temporary basis, ma'am?
Yes, sir, I do.
Where?
I could stay at a friend's house in Fort Walton Beach. His name is Michael.
Okay. What I'm going to do then is let you pick between a bond and a conditional release. If you want to post a bond, and some people prefer a bond, your bond is $2,500 cash or surety. If you want to accept the conditional release, then I'm certainly going to offer you that. But you have a condition of no contact with the alleged victim. And I want to be very clear. I'm not keeping you away from your child you have in common. I'm only keeping you away from that person, I guess the father of the child, the alleged victim. So you, the person accused you of this is the father of the child, correct?
As far as I understand. Yes, sir.
Yes, sir. That wasn't a trick question. I was just trying to, okay. All right, so Ms. Johnson, just stay away from the person that's accused you of this. I just didn't want to assume that was the father. I don't know. Stay away from the person that's accused you of this. That's what I'm trying to get to. And you want to accept the conditional release, is that right?
Yes, sir.
I'm gonna grant you the release, ma'am. Did you hear the instructions I was explaining earlier to Ms. Brown about using the phone and bringing you to the courthouse and all that stuff?
Yes, sir.
Okay, same thing applies to you. Contact friends or family for transportation if you wish, other than the alleged victim, and you'll be at the courthouse in probably 30 to 45 minutes to get that conditional release authorized and filled out by the officer. We're also gonna give you a notice for your court date, ma'am. Ms. Johnson, thank you. Your notice will be March 30th at 9 a.m. and they will give you that notice when you come to the conditional release office. So Corporal, Mr. Goodson's got the notice in his hand. He'll take care of giving her notice. Ms. Johnson, do you have any questions? Any questions?
I do have one question.
Okay.
For the conditional release, am I going to report to the courthouse weekly?
By phone. Yes, ma'am, but it's by phone, not in person.
By phone? Yes, sir. Okay, understood.
All right. Have a good day, ma'am.
Thank you.
Yes, ma'am. Richard Adderson. Mr. Adderson, good morning, sir. Mr. Adderson, you're here because you've been charged with one count of uttering a forced instrument and one count of exploitation of an elderly person or disabled adult. Mr. Adderson, there is probable cause for the charge. I've also looked at your criminal history, so I'm aware of it. You've got quite a few prior charges. But I'm going to appoint the public defender's office for first appearance purposes today. Please listen to Mr. McDaniel and we'll see if they have any additional information. Mr. McDaniel. Mr. Mitchell. Does he prefer a cash bond since there's allegedly restitution owed?
Mr. Adderson, I didn't talk to you about this, but if there's a cash bond option, that way, would that be an option? Usually he'd set it at 10%, same amount it costs to go through a bail bondsman.
Yes.
All right. Yes, Your Honor.
So, Mr. Adderson, given that, Mr. Mitchell, any objection to that?
No objection.
Anytime there's restitution allegedly owed, I try to set a cash bond because that money could go towards restitution. Now, if the case against you is dismissed, the money's returned to whoever posted it, Mr. Adderson. If there's restitution ordered, that's what it's there for. So your cash bond is $500 in each count. Instead of a $5,000 surety bondsman, it's a $500 cash bond. It's the same amount you'd pay usually. It's just going to the clerk, and the clerk holds that money. So you've got a total bond of $1,000. Mr. Adderson, you do have a condition of no contact with that alleged victim, sir, and you will get to use the phone in just a few minutes to try to post the bond. Mr. Adderson, do you have any questions?
No, sir.
Have a good day, sir. Oh, I'm sorry, Mr. Adderson, I need to give you your court date. That would be when? April the 7th at 8:30 will be your court date, sir.
Thank you, sir.
Yes, sir. You have a good day.
Yes.
After Mr. Adderson, we have Brandon Bronner. Mr. Bronner, good morning. Mr. Bronner, you're here because you've been accused of 4 charges. Let's see, there's 2 felonies and 2 misdemeanors. The felonies are possession of methamphetamine and possession of ammunition by a convicted felon. The misdemeanors are driving while license suspended knowingly and possession of drug paraphernalia. There is probable cause for all those charges, and your criminal history is very lengthy. Mr. Bronner, I'm going to appoint the public defender's office to represent you for first appearance purposes. Listen to the attorneys, and then I'll set your bond. Mr. McDaniel?
Nothing, Your Honor.
Mr. Mitchell?
We just request to be subject to random UAs.
Mr. Bronner, on the 2 misdemeanors, your bond's gonna be $3,500 each. On the possession of methamphetamine, it'll be $7,500. And the possession of ammunition by convicted felons, a higher degree crime, so it'll be $15,000. Mr. Bronner, when I add those together, I get a total of
I got
$29,500 cash or surety. Surety means you could go through a bondsman if you wish. And you do have a condition of random urinalysis because one of these is a drug-related offense, at least one. So, Mr. Bronner, you're going to get used to phone, sir, in just a moment. And if you post a bond, you'll be released. If you're not able to post the bond, Mr. Bronner, then the public defender's office will be in contact with you at the jail. And Mr. Bronner, the jail's also going to give you a notice for your court date, which will be April the 7th at 8:30 a.m. Mr. Bronner, any questions?
No, sir.
Wish you the best, sir. All right, so Corporal, unless I missed someone, that's it for first appearances.
All right, that's it for first appearances. He does have a bench trial this morning, so we'll probably get to that here shortly because we knew coming into today that was a possibility. But let's go back up to Judge O'Donnell, new contestant.
This is 19 CR 15, Janai Bynum. We're here for a review hearing. Ms. Bynum, what's going on recently with your treatment?
I'm with Your Recovery in Beechwood,
And what are you doing there?
IOP.
How long you been there?
I just started,
All right. How long a program is it?
3 months.
Okay. You're on probation. Ordered to do?
Yes.
Okay. What else are you doing?
I've just been sewing and spending time with my kids, just trying to stay out of trouble. I just recently got my ID so I can get my medication and find employment. So other than that, I've just been trying to stay out the way, stay out of trouble.
All right. You've your history in this case is you disappear for periods of time and then you show back up, and so you've been on probation a long time, but you keep interrupting it with no-show periods. Okay. I'm going to extend your probation to December 17th of this year, which is consistent with your Cuyahoga probation. And I'm going to transfer the supervision of your probation to Cuyahoga County, so you'll just report to them. You won't report to Mr. Tompkins anymore. But Mr. Tompkins will stay in touch with your Cuyahoga probation officer to find out if you're complying with the terms. All right?
Okay, thank you so much, Your Honor.
Any questions?
No, Your Honor.
Okay. Anything from you, Mr. Fatika?
No, thank you, Your Honor.
All right. Good luck, Ms. Bynum.
Thank you so much.
A tame hearing out of Judge O'Donnell's court. So for those of you who said that you had like freezing, I've got nothing showing on this end, so what's going out is good. I'm guessing in this case it is your local internet connection, not us. Although we will be making an upgrade here over the weekend to hopefully combat some of the tech issues that we have seen cropping up in the last week or two. Won't change anything that you see, but it will change things on this end, hopefully for the better. Anywho, back to Wade Mercer. He is, looks like he's going to start a bench trial. This is State versus Williams. Let's see what's going on.
Jackson County case 25-489 which is State of Florida versus Harvey Williams. And Mr. Williams is present along with his attorney, Mr. John McDaniel. Prosecuting for the state is Mr. Jake Mitchell. And Mr. Mitchell, are you ready to proceed?
Yes, Your Honor.
Mr. McDaniel?
Yes, Your Honor.
All right. So we're here for a bench trial. There's been a stipulation that the standard stipulation that if the defendant is found guilty, he can only be sentenced to probation and a withhold. The reason I didn't sign the proposed order is that didn't mention the possibility of, it implied that there'll be no jail time possible. There's no jail time possible unless he gets probation and violates. So that's not in that motion. You're shaking your head no.
Yeah, because the statute says no jail time at all.
No, that's not the law. If he gets probation and he violates that probation, which are two big ifs, he could be sentenced to jail time. It's my understanding. This is the very first time I've heard you say this.
That's the reason why I said that I have no control over it. If y'all agree with this right here, and if y'all want to do that, then you're gonna do what you do, but it'd be an appealable issue. And I mean, that's just something that I think the statute means no jail time. There's no possibility of jail. But I could be wrong. You could be right.
Mr. Mitchell.
First time I'm hearing about that issue.
Same
right there,
here.
but-
Same here. So we're going to go ahead and go forward. That should have been brought up before now. As many times we talked about that, that's never been mentioned. In
Yeah,
fact, I
absolutely.
said the same statement on the
Judge,
record earlier. I made the same statement on the record earlier about the possibility of jail time. Mr. William wasn't here that day. And that
If there's jail time possibility, we're asking for a jury trial. I've made that clear in an email to y'all. I said, you didn't sign that order. There's gonna be no jail time. And you still haven't signed it.
not going to sign it because that's not the law.
Then we're demanding a jury trial, Your Honor.
All right. So we're going ahead with a bench trial. We're not having a jury trial. The state has a right to compel this. My understanding is, and we'll cross that bridge if we come to it. So you also filed a very, very, very late motion this morning at 7:54, the day of the trial. You want to put anything on the record regarding that motion?
Judge, just that this has been superseded. It's been delegated from the state to the counties and cities to regulate these issues. And, and I can already tell that, we're just saying that, Your Honor, the motion, we got it filed and just ask the court to take that into consideration, that all these issues have been delegated to the city and county. The state attorney's office does not have, this is not a state crime. They don't have authority to come in and prosecute city offenses. I don't even know if the city has delegated it as a crime or not, but he's not charged under a city charge of a criminal offense. It's not the city attorneys here prosecuting the case. They've got him charged, kind of bootstrapping it under a state crime where the legislators already delegated that stuff to the cities and the counties to regulate.
I think there may be a typo in the statute number. We just need to make for appellate purposes to make sure the record's clear. Your statute, your second motion to dismiss filed today
I checked it this morning and I'm like, and I was like, God, and I tried to type stuff up real quick, and I apologize.
It's just, I think we all know which statute you're referring to.
837.
Because I did go and read that. Obviously, I don't have time to look at the case law since it was filed so late.
837.27.
Thank you. Mr. Mitchell, anything you want to put on the record regarding that very recent motion?
837.27. So when I look at Florida statutes, that just comes up as perjury.
Excuse me. It should be 828.27.
828.
Instead of 827, it should be 828.
Okay, let me go and look at that.
And probably what we're going to do, since we have so many witnesses waiting and since it was filed so late, is I'm just going to have to take it under advisement. And since you haven't had a chance to read it closely either, we'll just take it under advisement and see what happens with the rest of the trial, and then I'll rule on that subsequently. So even if I felt like his state's proven their case today, I probably won't sentence him today, Mr. McDaniel, to give me time to go back and read your motion, give the state time to respond.
Yes, sir.
All right. So, other than that, Mr. Mitchell, anything else from the state before we start the trial?
I do have witnesses here in the courtroom. I don't know if you want to go in and enact the rule of sequestration, I believe.
Is either side requesting that?
Yes, sir.
Okay. Can you give me the name of the witnesses that are here?
Yes. We got Sergeant David Herndon. We got Lieutenant David Riley. We got Gary Dickens and Emerald Dunstan.
Okay. The individuals is that all of your witnesses, or do you have more witnesses that aren't here?
I had witnesses that were here, but I released them from their subpoenas. So
these are the only witnesses you anticipate calling?
Those are the only witnesses I anticipate on call.
All right. So, ma'am and gentlemen, ladies and gentlemen, a rule of sequestration of witnesses has been invoked. And what that rule says is that from this point until the completion of the case, you cannot talk to other witnesses about the content of your testimony. You can certainly talk to other witnesses. You just cannot talk to them about the content of your testimony. So what we have to do is have to have you outside the courtroom until it's your turn to testify. We'll bring you in, let you testify as soon as Mr. Mitchell gets ready to call you. But just don't talk to any other witnesses. Someone can't testify before you and come out and you say, what did they ask you? That's inappropriate under this rule. So I'm going to ask you, where do you want them seated at, Mr. Mitchell?
They can sit in our office. We instructed them on that yesterday.
So Roy's going to help them. Investigator Jackson is going to have to show where you can wait at, and we'll call you as soon as Mr. Mitchell gets ready for each of you to testify. Any other witnesses before we begin? Any other issues before we begin, Mr. Mitchell?
I don't think so, not this time.
Mr. McDaniel, anything else?
No, Your Honor, I apologize to the court. I'm fighting for my client, I mean, I know the court is upset that I filed something.
I'm not upset that you filed something. I'm upset. I don't like that you filed it so late. But, you've got to do your job, so I
I'm just
understand
doing
that.
my job, Judge. I mean, I apologize.
I
I'm not trying
understand
to, I'm trying
No,
to
it's
make it
okay.
difficult on the state. I'm just trying to, because I feel like I know what the law is, but I just could never put my finger on it.
It's an interesting argument, but in fairness to both sides, I need to read it closely and carefully, which I don't have time to do when I've got first appearance responsibilities and a trial an hour after it's filed. So, Mr. Mitchell, why don't we do a short opening statement to give both sides a kind of a chance to, I know we don't do that a lot in bench trials. I just kind of like to know, at least have the option to do an opening statement to tell me where you see this case going, what the primary issues are. Was anything you'd like to let me know ahead of time, Mr. Mitchell?
I mean, I was planning on just waiving the opening statement,
That's
but
fine.
I'll leave it at that.
Okay. And Mr. McDaniel?
Your Honor, the defense theory in this case is straightforward. This is a private dispute between neighbors, not a public nuisance. Florida law requires community level impact, citizens in general, and interference with public rights. The evidence shows none of that I've seen. It's important to note that what the case law shows more accurately, there is no case law on this. I mean, I couldn't find anything. I asked other people to help me research and find, other trial levels where this has happened. No one's ever been able to find a case where it's happened at a trial level where it went through a trial. Except for, now there's plenty of them on municipalities. There's plenty of them on, county level that was tried in the county court, but I couldn't find any at the state level as it relates to animals and dogs in this nature. Historically, the statute's been used for drug houses, brothels, illegal gambling operations. It's never been used for isolated neighbor disagreements. And certainly not one as entailed in the information that's been charged here and then with the facts that we have in this case. I think that underscores the state's arguments, but we'll go forward with it. And finally, I think it's important to note is that the city, this is a due process case also because the city has no civil enforcement. They don't have a special master. They don't have, any kind of mutual forum that they can resolve issues with. All they have is a ticket system which says that you can basically ask for a hearing where there is no hearings. There's nothing even available. There's not a hearing even available. They got an enforcement system that they cannot manage themselves. They cannot even work themselves. And because of that, that's why here they're trying to say, well, we're going to use the criminal, we're going to make the state attorney's office use a criminal section because we can't do our own civil stuff. And I think that's a due process issue that's been going on with that.
It sounds like that your primary argument is related to your most recent motion to dismiss, which we can't hear. So I want to give you a full time to explore that and make your argument. So again, in regards to that particular argument, I'm not going to rule on it till I can read everything and give Mr. Mitchell a chance to read everything.
And it was a late argument to me. I still obviously would have liked to have done more research on it myself. That's why this is what I was originally going to argue right here. I mean, there's also the issue is that's separate from that. And there's also the issue is that, the motion I filed this morning, the legislator has given the local authorities this jurisdiction to handle, not the state.
And that when I tried to read the statute this morning, it does use the word may. So when we have our further hearing, I'm gonna need some clarification on why you believe they've given exclusive jurisdiction when it says that the cities may enact something.
Because if you say shall, that means they got to go out and enact something. But when this legislator says they may do that, then that gives them the authority to do it. But if they don't do it, then there is no authority. There hasn't done anything.
And I'd be interested to see a case that says what you just said. Any case that says what you just said.
That's just legislative intent and legislative. That goes off legislative intent of it.
There's no case, in other words.
I don't know. I haven't. I mean, I'd have to do some more research.
But we'll give you a chance to do that.
Yes, Your Honor.
Okay. All right. You ready to call your first witness, Mr. Mitchell?
Yes, Your Honor. State will call Sergeant David Herndon to the stand.
Okay.
James.
You got your oath card, Dawn? You know this one? Just don't embarrass us. Sergeant Herndon, come on up, sir. I'm going to ask you to stand right here next to Sergeant Applewhite, and Miss Williams is going to place you under oath, sir. Thank you. And Mr. Mitchell, whenever you're ready, sir.
All right, thank you, Your Honor. Good morning. Can you please state your name for the record?
Yes, sir. David Herndon,
And where do you work at?
the Mariana Police Department.
What is your rank and title?
I'm a patrol sergeant
And how long have you been with Mariana Police Department?
since June of 2011.
Do you have any other prior law enforcement experience prior to your service with MPD?
No, sir, I do not.
Okay. And were you employed with MPD on August 29th, 2025?
Yes, sir, I was.
And you were on duty that day?
Yes.
And while you were on duty, were you equipped with a department-issued body-worn camera?
Yes, sir.
And was it in proper working order?
Yes.
So what happened on 8/29/25?
So at about 7:20 in the morning, we were dispatched to the area of Herring Avenue and Martin Luther King Road in reference to several dogs running loose. Dispatch advised that they were called in as German Shepherd breed dogs running loose in the area.
And that address, or Herring Avenue and Martin Luther King, is that in Mariana, Florida?
Yes, sir, it is.
Jackson County, Florida?
Yes, sir, located right off Pennsylvania Avenue.
Okay. And when you arrived at that address, who did you initially make contact with?
So when I arrived, I actually arrived on Martin Luther King Boulevard. Captain Scarborough had already made contact with the original complainant, which was over on Herring Avenue.
Do you remember who the original complainant was?
Miss Emerald Dunson.
And does Miss Dunstan have any animals of her own?
She does. She has a dog fenced in her backyard.
So it was fenced in?
Yes, sir. Chain link fence.
Was it roaming around outside of that fence?
No, sir. No, sir.
Relevance. Objections, relevance, Mr. Mitchell. I started to say sidebar, but we don't have a jury here.
Yeah, jury, I mean.
Just asking to basically show that the dog was not out of the fence roaming around, causing the other dogs to run about.
I think that it could be relevant because if that dog was out of the pen and in heat, then that could be relevant. So I'm going to overrule the objection, but go ahead, please, Mr. Mitchell.
He's not a veterinarian to describe whether he's in heat or not. I mean, I don't know, but that would be relevant.
That may be
when you arrived.
In her backyard.
And that backyard is fenced in?
Yes, sir.
And when you spoke with Miss Yes, Mr. Mendoza?
I know that
you asked the same question a couple times. Go ahead, Mr. Mitchell.
Oh, okay.
On, please.
When you were speaking with Miss Dunstan, did she provide you with anything?
I was overhearing her conversation with Captain Scarborough at the time.
And did she show you any videos at any point?
No, sir. I believe Mr. Gary Dickens did, who was also present.
Okay. And when you spoke with Mr. Dickens, what videos did he show you?
He showed me a video of several dogs running loose in the area.
And while you were speaking with Miss Dunstan and Mr. Dickens, what happened?
While I was actually speaking with Mr. Dickens and Captain Scarborough was speaking with Miss Dunstan, they pointed out, there they are. And we turned and looked back towards Martin Luther King, and several additional dogs were running in our area, running towards our area.
How many dogs did you observe?
I recall 2 at that time.
2 at that time?
2 at that time, yes, sir.
And were they in Miss Dunstan's backyard?
They were positioned actually in Miss Irma Daniels' backyard, running towards Miss Dunstan's backyard.
What were they doing?
Barking, being somewhat aggressive.
What did you do in response?
I grabbed my department issued taser and issued a spark test and walking towards them in an attempt to get them to retreat and go back into the wood line.
And was it effective?
Yes, sir.
And you said they ran back into the wood line. What's on the other side of that wood line?
The residence located at Martin Luther King Boulevard, I believe Mr. Harvey Williams' residence. And positioned it in the driveway and began honking my horn and activated my sirens in an attempt to get him to come out. That's in an attempt to get him to come out to me.
Okay. And did he eventually come out?
He eventually did, yes, sir.
And you said that the homeowner is Harvey Williams.
Yes, sir, that's correct.
Is Harvey Williams in this courtroom today?
Yes, sir, he is.
Can you please point him out and identify him by an article of clothing?
Mr. Harvey's right here, wearing cream colored long.
And you gesture to your left.
Yes, sir.
Okay.
I apologize.
And Your Honor, the witness has identified the defendant in the courtroom.
Okay.
And did you have a chance to speak with Mr. Williams?
I did.
And what did you say to him?
Initial contact with him was actually Captain Scarborough. He informed him that we, while we were there, and that we may actually be seeking to take the dogs into possession.
Can I approach the witness?
Sure. What is it now? Is it relevant, do you think? I think you just described what happened. No, there's just cumulative evidence. He's just described what happened. The idea of just having to play a video that he just described, I think it's just cumulative. Okay, I think the state's got the right to introduce the best evidence if they want to do that. Is that what you want to do? Okay, go ahead, please.
So Sergeant Herndon, I'm showing you what has been marked as State's Exhibit A, or what will be marked as State's Exhibit A. Do you recognize what I'm showing you?
Yes, sir.
And how do you recognize this?
As a copy of body worn footage, with my name signed at the bottom of it.
Okay, so those are your initials on the bottom.
Yes, sir. It says Sergeant David Herndon with my badge number also.
And have you had a chance to review the contents of your body worn camera?
Yes, sir, I have.
And does this fairly and accurately depict what happened on August 29th, 2025 and your interaction with all parties involved?
Yes, sir.
Your Honor, at this time, the state will move to introduce State's Exhibit A.
Mr. McDaniel. Foundation purposes, Your Honor, I think he's modified that, so I don't know, has it been viewed since it's been modified?
What do you mean?
That's modified, isn't it?
It's an edited version to cut down fluff and normally what we do.
Has the officer viewed that?
Yeah, officers reviewed the entire contents of the body cam.
Yes, sir.
Yes.
That's not the question he asked. Mr. McDaniel said as the officer reviewed that video was his question.
Edited version, he has not, but there's nothing out there. There's nothing that's been taken out that would be prejudicial to the defendants.
Foundation purposes, Your Honor, objection. So how did he get his initials get on there if he's never seen it before?
Reviewed his entire body camera. I'm the one that makes the edits in the very end of what I believe needs to be cut out and what can be taken out for time purposes.
Okay, and then how does it get his signature on it?
He signs it.
Without watching it?
He has reviewed it through, what is it, your drive?
Yes, through our
The drive.
That actual DVD that's in his hand?
No, it's not that actual.
Okay, so I'm not getting a clear answer. It's a very simple question. Has this witness seen that video in your hand?
This particular, on this DVD, he has not reviewed the DVD, but.
Okay, so how did he get his signature on it? You said, here's something that includes a video. Can you sign it? Or how did he get his signature on it if he's never seen it?
This is our DVD that we have in our office for purposes of the videos that are downloaded from their drive and sent to our office.
How does it get his signature on it?
I gave it to him and said, this is the copy of your body cam
Okay.
that you provided to us. This is what's on there.
So it's admissible then, but only with the understanding that if the defense wants to introduce the entire video, they may have the right to do that. Okay.
We'll leave
So
that up to the
it'll be
defense.
admitted under that, with that understanding as State's Exhibit number A. Mr. Mitchell, go ahead.
We're going to just go ahead and raise our objection, and then we'll ask that the entire video be entered then.
Okay, it's up to you. You're in charge of your case. You want to play this now? You want to, this is admitted evidence. Do you want to play this or do you want to do something different?
If he wants me to play the entire video, I can play.
To the entire video.
About 50 minutes. I cut this down for.
That's fine if y'all want to watch the video.
You just do your case how you want to do it. And if Mr. McDaniel wants to introduce something, he has a right to try to do that also. I'm just telling you, in an edited version, always is there a possibility of something else coming in if the other side wants to.
Okay.
And there may be something, harmful to both sides. I have no idea. So do you introduce this or do you want to go do something else?
We'll introduce. This for now.
Okay, it's introduced. You want
Yes. Just say that.
I don't know what you do.
Well, that's what I do. Just, Your Honor, I wanted to make a comment that I cut the video for purposes of only playing relevant portions as it comes to the state's case, cut out all irrelevant portions that doesn't really need to be published.
Okay.
So.
All right, and that's not uncommon. Thank you for doing that, shortening the video, and we'll see if Mr. McDaniel wants to play something in addition to that. He may not agree. There may be something that he thinks is helpful to him that you cut
Okay.
out, but that'll be something we deal with later.
Oh, no. Do not tell me.
Showing the same thing again. Y'all tested it yesterday, right?
Yeah, that's the yesterday. This exact way. Prosecute C1.
Hey, we're trying to play a video in the trial. It's doing the same thing it did last time. Are you where you can step down here and help us, please?
Yeah, I can come down, sir.
Thank you. He's on his way.
So there's some people in the chat concerned about the picture fading in and out. Some of this that you're seeing is tech stuff going on in Judge Mercer's court right now as they're attempting to connect this video. They're cutting their feed and it's coming back and it's playing games. So it's got nothing to do with our connection. It has to do with them being rather inept, it would seem, when it comes to making stuff work in their courtroom. So, but let's see if we can do this. We're a little bit in the Wayback Machine. Let me see if I can punch this forward past some of this crazy. And I can't. We're now real time and they're still struggling. So let's do this. We'll come back. But for now, let's go to Judge Stevens and I'll come back to the bench trial when and if they get their text sorted.
You talked to your attorney lately?
Yes, sir. She's here.
Is she here? Did not hear?
Now some misdemeanor report to Cleveland and Plainfield.
Oh, no, that's more important.
No.
That's the way I'm taking it. That's the way I'm taking it.
It was a case that's gonna be dismissed here for a plea in misdemeanor court, so they went over there to plea in misdemeanor court.
Here.
Big-
We take misdemeanor.
But it wasn't a lesser included offense, Judge.
What we do? Have jurisdiction over misdemeanors in this court as well as felonies.
So if they refiled as a misdemeanor, I'm not deputized by the clerk.
It's his case.
No,
It
it's
was
not
his case, or they
it's
disposed of
not
his case
his.
that way?
No, sir, it's not his. It's a separate matter altogether.
Oh, all right.
Yes,
Well,
that's what, but that's why she's not here. She.
when she gets back,
To misdemeanor.
we'll see where we are on this. Okay, stand by. Thanks. You can go outside and stretch your legs if you want. Xavier Curtis. Mr. Curtis, you've got the same lawyer as the previous gentleman, and we got to wait for her to get up here, and then we'll take care of that. Jose Granados Castillo.
Judge, that is the defendant that Ms. Ali has down in misdemeanor court doing a plea. And in that case, if it's here in this court, we already have the dismissal.
Okay, we'll do it after we know they didn't change their mind.
Okay.
Okay. Victor Hugo Chavez, the famous name.
Good morning. And he speaks a little bit of English, Judge, but most in Spanish. So.
Victor Hugo, see. What did he write? Give me one. I mean, he's a great writer. Great writer. Mystery writer, among other things.
He wrote a mystery.
Good answer.
I know for y'all it is. Great writer, famous person. Victor Hugo Chavez, that is you.
Yes.
All right, it's a DWI third. What are we doing today?
If I can get 28 days, Judge, we'll be.
How about 4 weeks? All can get.
I'll take it.
All right. Okay, we'll move it then, you think?
Yes. Thank you.
Anything we need to deal with? Do you speak English? A little bit? Muy poquito. Okay. Charlie, did you make sure he has an interlock device in any vehicle he operates?
Yeah, I discussed that with him. He does not at this point. We're going to get it by next week.
You cannot drive a car without an interlock device. Is that understood? Comprende? It's very important. If it happened, if we caught you doing that, then your bond would be revoked and you would stay in jail until this case ends. You have to operate a motor vehicle responsibly and safely. Understand? 4 weeks, Charlie?
Yes.
Okay, thank you.
Thank you.
Did Granados Castillo get taken care of? In the, it was going to be in another court, right?
Yes, Judge.
Oh, I thought that's where you were.
I was, they had to add it to the docket. I'm sorry, they're working on that right now. For what?
Please, fine. Whatever. Yeah, whatever.
Okay.
DeMarcus Roy.
So there was a custody of his partner, Jamie.
That's correct, Judge.
Bill?
Bill. We're just keeping it on the docket so that.
We sure.
Cracks.
That's what Kelly said this morning. There's mine.
I thought they only had one cell.
Okay, that's great. I just wanted to hear.
Okay. So we're gonna call into the hall, see if he's here. If he's not, we're going to make sure that he is in the Hardin County Jail before I make any findings. DeMarcus Roy, no answer in the courtroom, and cause number 25 CR 338. I asked the bailiff to call into the hall for DeMarcus Roy. While we were waiting, Devontae Jobert, I'm seeing this has been reset a week.
Yeah.
No longer after that. That's it.
And Judge, I will let you know on that, that part of that is, getting an update on the blood discovery. I heard from the crime lab and all that's been completed, so hopefully it's supposed to be en route to all the parties.
And there's no answer to
No answer.
DeMarcus Roy. He may very well be in the Hardin County Jail. If he is, then we're going to set this for a review in a week. I just want a week. Hopefully.
The inmate roster now, he's there. He's in Hardin County.
Is that his picture
That's
right
his
there?
picture.
I'll be done.
Yes, that's very.
Certainly looks like he's incarcerated there.
Well, it looks like to me too there.
Okay.
So I would say maybe
Why don't we review it in 2 weeks just for status? Let's see.
Yeah. I mean, we have a hold on him, so
Okay.
he'll come back.
All right. And Anthony Smith. Spurl. Okay. Spurl. It's Spurl. You were racing, jumping the gun there. I was going to catch you. I'm heading to Newton next. Taking off before the gun fired. On Mr. Spruill. In cause number 25 CR 541, you were charged with a third-degree felony of failing to comply with sex offender registration that you're required to register annually, I presume. This states that you failed to do that in 24, and then you were indicted last year in May for this third-degree felony. If it were only that, there's obvious when you have a duty to comply with sex offender registration, that means has to be a conviction in the background. And in 2022, out of Harris County, Texas, you were convicted of sexual assault, which requires you to report. And this third degree felony is what has occurred. Have you complied with reporting responsibilities as of today?
Yes, sir.
Okay. If convicted of this is a third degree felony, which carries with it up to 10 years in prison. But because of the prior conviction, if you were convicted and that prior conviction was proven true, which it's likely based upon the way the indictment is worded, then you would be facing second degree felony punishment. It gets enhanced. So then you are now looking at up to 20 years in prison, which is serious. All right. Today, what do we do?
I think we're going to set it on the trial docket. We've talked quite a bit about this. We've been back and forth with the state, with my client, and we believe that the evidence shows we disagree on the evidence, I believe.
Okay.
Judge, this case, so I did defense counsel provided me with some information. I did some digging, and I was able to see that the defendant registered in another state in July of 2024. And then there's a gap where he didn't register back in Port Arthur until January of 2026. So I'm going to have this case refiled for the 2025 failure to register instead of this 2024. So it'll come back re-indicted under a new year.
Okay. All right. You have a hand raised.
I don't live in Portland. I live in Houston. This is not time to argue about Portland. I know, and I've seen the documents. Don't worry about that. That's part of that's why I said we disagree on the evidence. Okay. So
he registered in Port Arthur. So I don't know where he lives at. That's where he's registered at. So if he knows his correct address, he should register elsewhere.
So just to keep it.
He must have a driver's license, my God, I would think. Oh, that's post your address there, but well, the ramifications are, number one, the Constitution states you have a right to a jury trial, and great. We've had more than any district court, apparently, according to what I've heard in research on trials. So we try cases here. But the issue is you have a prior conviction, apparently, which means if you are convicted, you are not eligible for probation at all. It would just be no less than 2 nor more than 20 years confinement in prison if what this indictment reads is proven beyond a reasonable doubt, which is most serious. And I just hope everybody is certain with their plans, but that's why we invented trials by jury. All right, I'm gonna just set it for the trial docket, for a trial. If y'all, when we re-indict, he'll have to come up and have another appearance for that, but I'm not gonna wiggle around on this. And this is odd because I've done this for a long time, and generally there's not a lot of confusion on it's
Generally,
a very
no, but
straightforward matter.
we have various
So-
different jurisdictions involved, that's the
So,
problem was moving around.
well, I hope everybody's correct because 20 years imprisonment is on the line.
Yeah, what's the next?
Okay, friends, real quick with regards to the Judge Mercer bench trial. So they were having tech issues trying to get this video evidence to show up on their monitors and stuff in court. And in the process, they completely nuked everything except their audio. So they played the body cam footage or whatever it was, and all you heard was the audio. And now they're back to questioning the witness, but the only thing we have is audio. If this were just a podcast, an audio podcast on Spotify, that'd be fine. It's not overly compelling for YouTube and Rumble and Kick and X viewers. So I think we're going to move on from that, unfortunately. I was hoping to be able to show you that bench trial, but they broke it. So we're just going to stick with regular, old-fashioned other courts. Back to Judge Stevens.
You were convicted 3 times in this court for aggravated assaults back in 2019. If one or more of those are true, then this 3rd-degree felony becomes punished as a 2nd-degree felony, which carries with it, if you're found guilty, and carries with it up to 20 years in prison. Also, you are not eligible for probation in front of a jury if you're convicted. You understand?
Yes, sir.
Are you still at 3444?
No, sir.
25th Street, Port Arthur? That's what I wrote down. That's what you told me at one time.
I'm old, sir. I'm on 21.
Well, you're supposed to inform the court as well as your bondsman all updated addresses, and all I have is 3444 25th Street, Port Arthur, which is in my handwriting, which means you told me.
Yes, sir.
You didn't correct it.
I did.
What is the correct address, sir?
2147 property.
That's in Port Arthur.
Yes, sir.
And 642 zip 77642.
Yes, sir.
Is that right?
Yes, sir. 77640.
It's 0.
Yes, sir.
Yeah, I thought Proctor Street would be 640 because that's going to be the original part of Port Arthur down there. Okay, that's corrected on this day. I'm looking at this probable cause affidavit, and so please arrest or stop the defendant, and there's marijuana in the vehicle. And according to the probable cause affidavit, the defendant says he had just smoked marijuana, and they found a baggie in the center console containing marijuana, and located a AR-15 rifle in the backseat floorboard. The police asked what the defendant was doing with the firearm. He stated he has had the firearm and it is clear. Okay. All right. You got to try it. You understand you're not eligible for probation.
Yes, sir.
All right. We're going to set this, put it on the trial docket, get a trial setting, and no deals on this. Get it and take a seat in the jury box. We're going to test you for drugs just to make sure you're okay. Get a resetting.
I take it that's going to be about the offer, not the.
I'm not taking any deals on that.
That's got to be the offer, no. Thanks. See you later.
Next is Xavier Curtis.
I'm re-indicting it, so they can bring what they had.
Oh, actually, I have the assaults on my indictment.
Right, so I'm doing some maybe.
Oh, okay.
Xavier Curtis, that's you?
Yes, sir.
In 25 CR 284, you were here with your attorney, McNally, and the state's attorney. Earlier, you entered a guilty plea on the second-degree felony of burglary of a habitation, and a pre-sentence report has been prepared. Have the parties had an opportunity to review it? Any corrections or changes to it necessary?
None from the state, Judge.
Judge, I don't know that it's a correction, but more clarification. Would you rather us wait?
Do whatever.
On page 4, whenever
Hold
we
on.
go,
Let me get to page 4 so I can look with you. Go ahead.
whenever we go under the first paragraph, under the recommendations portion of that, there is a sentence in there that talks about him committing the offense and accepting responsibility for his actions. But then whenever he was later asked about his past or present mental health history or treatment, he said that he never had any issues. I've talked with my client about that statement.
Was that, yeah,
And
what does
he has
that
let
really
me
mean?
know- He has let me know that before this incident and before this depression that he was suffering, he thought the question was, had he been treated for any mental illness of any kind like that?
I thought it was,
That response is.
I thought it was unclear.
Was a lack of a clarity question. So he was suffering from depression at the time that this offense was committed, but he has not ever been fully evaluated for mental health issues, and he has never been deemed insane or incompetent or anything like that. And I think that that was his interpretation of the way the question was asked.
Is that true? Okay.
So that's the only thing that we wanted to provide some clarity on.
What do you do now, sir, for a living?
Right now I still work for toiletry services and removal, but I've also just got hired on to another job. I got confirmation for that Monday. They called me to come in and do my orientation and whatnot, and I'll be working at Burger King on East Texas in front of the mall. And I start that Friday.
Okay.
And I'm supposed to be receiving a phone call today on the things that I need, such as like
to get ready to start
my uniform and things like that.
All right.
So and yeah.
So that would start Friday, and then you also do the kind of odd jobs with the tree cutting and everything else too.
Yes,
Okay.
I do that whenever he calls me or he feel that he need me, he'll call my phone and I'll go out or I'll go meet him and we go work for that day and I get paid for that day. Which is the range that I get paid for the day is between 100 to 150 a day, depending on where we go on. And how many trees we gotta cut and locations, because sometimes we go Deweyville, Mauriceville, and other strange places like that. They whatnot, but as far as that, I will start working a full-time job starting Friday.
Did you know the victim in this case?
No, sir.
You randomly chose this place to
Yes, sir.
burglarize?
Yes, sir. We had, the last time I was here before it got reset for the citizen, you had asked me and.
Yeah, I have 5,000 cases, so forgive me if I didn't remember.
It's okay.
Because your face is familiar. I remember the faces. I just don't remember
Questions.
the exact subject matter of every one of the 5,000.
I know, sir, I did not know the changes, and it was just random. Due to the state of Miami. Fishing about at the time.
Well,
Just actually something you understood everything that was told to me, and I understood the crime that was also committed to, and which I stated that I do feel guilty of the crime, and I was lawfully removed because that's taken from someone, and no one deserves to be actually taken from, especially if they worked hard for everything that helped them. So I understand everything that's going on. And right now, I'm just begging for a second chance of life to get everything back on track.
And Judge, if you'll notice the criminal history, I believe he was also furthering a habit at that time. The majority of his issues with the law before then are possession issues, are drug use issues.
choice issues.
Right,
Yeah.
choice issues too.
I've learned how to also manage it because everything in life has to do with the decisions and choices. The choice that we make is
Unless you're
how I would like
forced
to
at
go.
gunpoint.
Yeah, but every choice and decision that we make,
That's
that's what our life is based on, is whether it's a good or.
I
it's
know
a
you're
positive
speaking
or a
that.
negative.
Yeah, I hear you speaking, but you've been through this before. You've been through this before. You were placed on probation in 2017 for illegal possession of drugs, and that was revoked because you failed to follow the second chance that was given to you.
Actually,
Then this is a solo right now. And then there was a felony as well. It looks like a companion case. You had a misdemeanor and a felony. And in that felony case, you were placed on probation a month after you were placed on probation in the misdemeanor and sentenced to 3 years probation. And then that was revoked at the same, on or about the same time the other one was revoked, which was a year, looks like a year later. And then you were sentenced to 3 years in prison.
Yes, sir.
So you've already had 2 second chances. This is a third one.
I understand.
Do you see it?
I see.
How many do you get before enough is enough for you to realize that mistakes have consequences under the law? And you have to know, you can't be bewildered about drugs on this one because this is a burglary of somebody's home, which is probably a more serious level of crime than the 2 drug cases you had, but they're still crimes.
Yes, sir.
It's like you didn't learn the first time.
I mean, now I've had time to reevaluate myself, and I also really.
How's that coming along?
It's actually coming very well.
Well, what have you what have you determined?
I'm actually determined right now. I'm in the process of looking for my own space of living, and the jobs, then also going back to school to finish, either get my GED or get my high school diploma. Then I also have plans after that. I really have a lot of things that I really have planned and that I'm trying to do with myself to get myself better and to make me a better person for not just myself, but also the world and society. All I'm really asking is for this chance to get myself together, which I've already started doing such things as far as handling my problems different. I talk to people. My support system has got better ever since the incident. I've been more talkative. I've been doing more positive and all types of sorts of things. I've been really keeping myself productive to keep myself from thinking negative and also remove myself from crowds that has a negative meaning also. So I've really been to myself and sticking to handling everything that's right for me that I need to do to make myself better and also my life better also.
What about this drug stuff that you're having problems working with?
No more. Do no drugs.
What did you tell do you remember what you told the probation office when they talked to you about this? They interviewed you.
Yeah,
they write down things.
We talked about multiple things, and the drugs was also one of them. I told them that I recently stopped smoking not too long ago because I was smoking marijuana, and I just left everything alone just to get myself together, to get my life on the right track as it needed to be and as I should have been doing. But
When did you stop the marijuana?
I would say maybe about 2 months ago, like I had 2 months ago, something like that. I think.
Since you've been on bond? God bless you. Oh, yeah.
On bond?
Yeah. You've been on bond, haven't you?
Yeah, I've been
Yeah.
on bond.
Yeah, and you're smoking marijuana on my watch on bond. You've been on bond for a long time here.
Yes, sir.
And you've been smoking marijuana while you're on bond. Well, is there any rule? I know you're saying something, but you're not doing what you're supposed to do. But you talk a good talk. You got to walk the walk.
As far as now, I'm willing to show and
Now?
prove everything that
You made a promise. You made a promise a long time ago. The first time you were on probation in 2017, you made a promise. I'm going to follow all the rules. I swear, Judge, in 2 cases that you failed. Then here, you made a promise when we let you out on bail to follow the rules, but you're smoking marijuana as fast as you can get it.
Sir, I promise you that was my only slip up during my period of being on bond, and ever since then.
I'm sorry, sir. You don't win the award for making a mistake. You made a mistake. You don't get the participant's trophy here. You've got to succeed in following the rules. And using drugs, acquiring drugs, possessing drugs are crimes.
So,
just not, oh, I ran a red light inadvertently, or I crossed the street, not at the intersection, I jaywalked. These are drug crimes, serious crimes. You know that. You've been convicted of these things before. And now you're up to a 2nd-degree felony, somebody's home, you're burglarizing, which is not good. I mean, these people have a right to privacy, and then you're You're saying things, you're just failing to do what you're supposed to do. But you certainly make promises, but you haven't kept the promises that I'm looking at here in this report,
Sir.
which is kind of your choice.
They are, and I agree with you 100%. But as far as now, everything is looking better than really it's ever been for me. And I'm doing my best to keep everything right and to do everything right. And that's it. I understand that the promises that I also did make, I did not keep. But I promise you now that with the mindset that I have and the things that I'm trying to do with myself and within myself, that they're going to be made and they're going to be met. And it's also going to make everything better, not just for me, but for everyone else, for me to be a better person.
Yeah. We're not through with this. I'm not ready for sentencing today as a condition of his bond that he's failed on. What we're going to do is I'm going to revoke his bond for his failure to follow the terms and conditions of bond. And he is going to be required to fully and completely describe where he's getting the drugs, who he's getting it from, before I do the sentencing. Like he says, he's been using them daily. And I want to know where it's coming from, that you're part of it. Dealers don't exist if they don't have the buyers. I want to know where this mess that you've gotten yourself into on drug abuse now has caused you to commit burglaries, a burglary. I want to know where the source of that is. And we're going to decide how forthright you are, because we're going to get to the bottom of all of this. You're not going to hide anything anymore from me, or else don't worry about it. We'll just put it on the trial document. What do you want to do? Fix your mess, clean it up, or not? All right. So you're gonna meet with law enforcement, and I want you to be truthful and accurate with that. And I'm going to ask them to, as a condition of that, provide that information, and I'll put it into the equation here. You don't have to talk to them, but I don't want that unless there's something that you need to talk to your lawyer about. I don't want some additional prosecution from it. I just want you to be forthright, as long as it's marijuana, which is still illegal, but not on my watch. You're not going to do that. I want to know who's the problem. I don't think you're the one growing it and selling it, but you're acquiring it. I want to get to the bottom of where that comes from for law enforcement purposes before I decide what I want to do here. And you're forthright with me, I'll reward you.
Excuse me. My friends.
Do we have a timeline on what that looks like, Judge?
2 weeks. When were you supposed to start work?
Friday.
Friday.
What do you mean Friday?
This Friday.
Okay, I want you to work.
Is there a way that he
I
can be
want you to
drug
work.
tested today?
Yeah, I want you to work.
And then
I don't know.
he can have a meeting with law enforcement over the
Yeah.
next 2 weeks
Uh,
while he's still
that's-
out on bond.
If y'all can work that out, that's fine, but I want him to go to work. What is it? Today's Wednesday?
Wednesday, Judge.
Okay, so you go on Friday,
How about we drug?
48 hours to do it,
He says again.
to talk to him, 48 hours to get with him. Okay. And the DA's office needs to be involved in that, too. But
Yes, Judge.
I don't want him starting probation and we've got these issues that aren't resolved about, the drug usage and now that's what the problem is it steps up to more serious behavior, like second-degree felonies and burglaries. It's just, in looking at the pre-sentence report, it's just, this really bothers me, that you're moving into more serious behavior. Well, but that needs to stop and it needs to get resolved with a more aggressive drug treatment plan, I think. That's what I'm thinking. But we'll see.
Understand, and I'm really willing to do anything to get the chance. Yeah,
All right.
Is there somebody specific? Is it going to be the DA's investigator that we are going to be working with?
I've asked the district attorney's office to handle that.
We can coordinate when we're not at the bench.
So he is free to start work on Friday. And his.
As long as he's cooperating.
Sure.
I want to reset this for a week though, just
Okay.
for a week, and then come back and finalize this, hopefully. Okay.
Okay, so
These are problems that it's high time they get fixed completely and sincerely, not, yeah, I'll go on probation, get revoked, then later I'm on probation, get revoked. I mean, that's not success.
I'm actually planning on doing everything correct.
Here.
I feel that.
Okay, I'm gonna reset a week.
Okay, 1 week, Judge.
Here's this.
We'll be back.
Thank you.
Sir, I think it's fine.
Yeah, it needs signs or something. Thank you.
Okie dokie, friends, let's change it up a little bit. We're going to go to Michigan. Judge Middleton is doing misdemeanor sentences. Let's see what that's all about. Oh, no, actually, let's hold on a minute because Weird Hair Guy just came back up.
Okay, bring me back on this one. His plan, y'all's plan is what? Set for trial. Okay, it will be set for trial. And you understand the punishment range is up to a second-degree felony with no probation no probation is an option if you've been convicted of a felony. And in this probable cause affidavit, it states you said you had the weapon, and it's clear, whatever that means. All right. Good deal. That's set for trial. We'll try it and see what happens. Okay. Thank you on that.
I already am on this.
Did you give it to him?
Okay, now we will go to Judge Middleton.
All right, so we're ready to go. We've got 3 sentences set for this morning. Sometimes I'll try to fit them in on a Wednesday morning if we have time. And we do. We have a domestic violence case here with Mr. Gibson. And then we have another matter. And then one with Ms. Strong. This is Cheyenne Marie Zarnecki. That's you?
Yes.
I was gone for a few days and I reviewed this case again yesterday when I came back. And then I looked at it again this morning. This is a prosecutor's offer for a deferral in a domestic violence case. This happened in January. You and your partner have both been drinking. Alcohol is kind of an underlying pink elephant in the room here. But otherwise, as far as I can tell, you don't have much of anything in it. There's criminal history, criminal record, and you appear to be appropriate for our women's anger management deferral. But Mr. Gibson, what would you like me to know?
I guess the defendant, I think there was alcohol mentioned in the report, but I don't know if the defendant believes that she was intoxicated.
No, I was not.
Okay.
Well, he certainly was.
Yeah, I let them know that he was. And they
But the
didn't.
report says, get him back into this file. First, there's the bond information report and then the whole report. Both parties indicated that Zarnecki started the altercation by placing a hand over Farmer's mouth and squeezing his throat. Farmer and Zarnecki were in a dating relationship for 5 years and had a child together. Both parties stated Farmer was intoxicated and a nearly empty 375 milliliter of vodka was at the scene. So he was the one drinking the vodka, not you.
No.
All right.
I barely drink.
All right, I had a broader attribution in that case. All right, well, go ahead, Mr. Gibson.
Thank you. So the defendant is employed as a security guard. She's only 22 years old. And so I believe that, with this situation, it was an unfortunate situation, but I believe that she can be, in a sense, she can learn from this. And I believe that the deferral is appropriate here. I would ask the court to sentence the defendant to probation. And if she needs, if there are any concerns about issues such as substance abuse, then I'm assuming the probation department would be able to address that. But I don't believe that alcohol is an issue with her, at least during this incident. So thank you.
Ms. Campfield, thank you. I don't know if you were involved in this or Abigail was, but at the pretrial, this is again pretty fast. This happened in January and we're doing the sentence in February, and she accepted responsibility. The prosecutor did not object to the deferral. I set it out for at least 10 days to get input from him and get the whole police report. I'm assuming still you don't have any objection to a deferral.
Correct, Your Honor. We don't have an objection to that. And Mr. Farmer has not activated his rights with or office or responded to the letters we sent for pretrial or sentencing. I do note that he was injured. He did have some scratches and whatnot from the altercation. The defendant indicated that she had had some bruises on her arm from the altercation. So I do think in this particular instance, due to her age and lack of history, that the deferral is appropriate, can assist in learning communication skills and triggers, and then how to cope with a lot of the strong emotions that come with trying to co-parent a child, a toddler in this particular instance. And I will note that the toddler was present during the majority of this altercation as well, which is concerning. So I think the counseling would
Well,
help.
part of what started the fight is he was gonna care for the child and brush their teeth or whatever while he was drunk. And then it all kind of went downhill from there. How old is your son?
He's 3.5.
All right. Now, I had a no contact provision in here. You guys were living at the apartments, what used to be known as Waterfront. Who's still there?
I am. He moved out the day I came back, or was coming back. He got out of jail.
Where does he work?
I'm not sure if he has a job or not yet, but he ended up moving with one of his friends up north in Grayling.
Oh, he moved to Grayling?
Yeah.
Ms. Zarnecki, it would be very good if you completed this probation.
Yes.
It entails a referral to the women's anger management class, the women's domestic violence treatment program. I started it when I was prosecutor a long time ago, 35 years ago. And now I use it all the time as judge, almost to a person. The women tell me that they thought it was valuable.
Yeah.
They liked it. They got good input. Very often, women that are charged with domestic assault are also victims of domestic assault. And so we try to explore that whole dynamic. Now, I told you at the time of the plea, I'll tell you again, if you hold up your end of the deal in this, the charge will be taken off your record and there will not be a public record of this conviction. Do you understand?
Yes, sir.
All right, I'm going to put you on a 12-month probation. I believe you got 1 day of jail. Well, 11 days jail credit, 1. Of the 11 days ordered, 10 are deferred. You're not going to do any additional jail time if you do what I ask you to do.
Okay.
I'm going to make the fine 0. There's a $75 crime victims' rights fee and a $50 state minimum fee. Those are required by state statute. There's a $150 attorney fee. There's a $480 probation oversight fee to pay for the class. You can do this probation in half of the time. So a 12-month probation, you can complete it in 6 months, which will save you $240 in oversight fees. Some of it depends on when the class is eligible. I had a guy this morning, he was 5 classes into his, I think, 26 classes. And he was enjoying the men's domestic violence program. I'm ordering that you go to the anger management counseling, no assaultive or threatening behavior, no drugs or alcohol. Test if necessary. I don't think for you it's a big issue, but you're not allowed to use any marijuana or use any alcohol while you're on this probation. I'm lifting the no contact provision. You can talk to each other. But you can't engage in any assaultive or threatening behavior. Now, has he had any contact with your son since he left?
Yes.
Okay.
My son has an iPad that he will call. Talk to.
Does he, well, little 3-year-olds are using iPads.
It's only for like an hour or 2 a day. I don't let him play on it all day.
Well, I'm not being critical. It's just, they were a lot smarter than I was. Your whole phenomena. My grandkids would stay glued to it if they, even my 2-year-old granddaughter is intrigued by it. What shift do you work?
I work first shift. So
are you missing work right now?
Yeah.
All right, well, these classes are mostly in the evening.
Okay. I get out of work at 2 p.m. every day.
What time do you go in?
6 a.m.
This is at American Axle?
The Morgan Olson's.
Oh, Morgan Olson. So you drive from Three Rivers to Sturgis every day?
Yeah.
I had it mixed up. Where are you from originally?
I'm from Manistee.
I think you told me that. How did you guys end up in Three Rivers?
Well, we moved around a lot, bouncing from my family, and then last place we moved into was with my aunt in Shipshewana, Indiana, and then I was finally able to get into my own apartment in Three Rivers.
Well, it's not a bad place to be. Those are pretty nice apartments. Who's doing your childcare?
He goes to the Carol Shippey Head Start for now,
Okay.
and then I have a friend that watches him for the couple hours that I go to work, and then she takes him to school. And then I get out of work just in time to pick him up.
All right, well, you got a system. And I would like to see you complete this and have this charge taken off your record. So I want you to take this form out to the counter. And they will get you plugged in. And I want you to hold up your end of the deal. If you can get this done in 6 months, I'll discharge you from the probation. Charge will be made non-public.
Yes, sir.
All right, good luck to you.
Thank you.
Paul, you've also got Alexander Pappas. If he's here early, we can start early.
Okay, I'll see if he's out there. All right.
Excuse me. I end up using a lot of these Wednesday slots for Casey Strong because she can't do Mondays because of the Kalamazoo obligations, but I only have one today. And I was gone for a few days, which kind of jammed up some of my sentencing spots, but this worked out fine. We got plenty of time to do 3 sentences. I hope that young lady completes this.
Your Honor, did you end up doing Mr. Sobey's sentencing this morning?
I did.
I was next door.
Well, what it wasn't, it was a no insurance case.
Okay.
And he has a bunch of tickets, but he'd get them at the same time and then he wouldn't answer the civil infractions. So they all got defaulted. He's on a payment plan. I deferred it to see whether he'd made his payments, and he made a payment in December, January, and February 19th, and he was going to make a payment today. So I just gave him an additional fine and put it as part of the payment plan.
Gotcha. Thank you.
I think he's lost his license from some Kalamazoo stuff, but he said he's not driving anymore. His sister lives in Constantine. She drives to Shipshewana and picks him up and takes him to work in Mendon. And I said, boy, that's a zigzag life, but
So while we're waiting for the next contestant, good morning to all of you once again. It's good to have you all here with me on this fine Wednesday. Thoughts with Michael Groff, who should be starting his doctor's appointment here pretty soon. Friends of the channel know that he busted his arm the other day, so hopefully he gets some good news on how to treat that here this morning. Tonight, assuming that nothing goes kitty-wonkus with Mike, we will have In the Blind with Mike and Dan. That is over on a separate channel. Barbara, I'm sure, will drop a link for us because that's what she does. Thank you, Barbara. But if you've not seen that show before, please do join us. It's 7 p.m. Eastern, 4 p.m. Pacific. It's a lot of fun. Mike and I spend an hour on the show. We are given 2 topics to discuss, and we have no idea what they are ahead of time. It's something different every time. And then my favorite part of the show happens after that, where we do a true-false round, where things get kind of crazy and we learn some stuff that we had no idea was real. And it's a hoot. So check that out, In the Blind with Mike and Dan. Looks like some contestants might be approaching here. So let's get back to court. Or maybe not. We'll circle back to Judge Middleton, but let's go say good morning, Judge Mom. Who is muted? It shouldn't be this hard to do court. Good heavens. Let's see here. Maybe they're not muted. It sounds like they've got audio issues, though. That's unfortunate. All right. All right, here. Looks like we got some stuff going on in Middleton's court now. Back there.
This is file number 252180 People versus Alexander Kennedy Pappas. That's you, sir?
Yes.
You're here with your lawyer, Mr. Paul Gibson. You entered a plea to this charge of operating while impaired, which was a generous plea offer. The matter was set for sentencing today. Mr. Daniel Frazine has prepared the screening report, and you're here with your lawyer, Mr. Paul Gibson. Also present is Angelique Camfield from the prosecuting attorney's office. Mr. Gibson, what would you like me to know?
The defendant, although he does have a criminal history, this would be his first drinking and driving offense. So at least I think that he was very, in his report, in the report that Dan wrote up, I believe that the defendant was very open and honest about his substance abuse issues. And so I believe that he does have, I believe, the ability to learn from this experience and to hopefully put this in his past, and hopefully this will be his first and last drinking and driving offense. The defendant is employed, and so I would ask the court to consider following the recommendation of the probation department, or in the alternative, sentencing the defendant to fines and costs and community service. Thank you.
Okay. Ms. Camfield, what would you like me to know?
Oh, Your Honor, I'm concerned about this case, and I do agree with the court that the impaired from my office was a very generous offer, and under the circumstances, I might not have tendered that offer. He did have a 0.22 blood alcohol level pursuant to his PBT, and then the intoxilizer a little while later showed a 0.171. He admitted having a Long Island iced tea at Applebee's, but he also had an open 25-ounce can of Budweiser in the cup holder of the vehicle when he was found in the lawn of the restaurant. So that does qualify as an accident. He was not on the traveled portion of the parking lot or the roadway. He was on the lawn, and that's very concerning. I have had an opportunity to review the recommendation of Mr. Frazine, and I do believe that it's appropriate, inclusive of the jail time, given the defendant's history and blood alcohol level during this particular incident. There's been polysubstance abuse in the past. Now we're drinking alcohol to excess and going off the road or parking lot area. It's a significant danger to himself and others. And I would ask that the court follow the recommendations.
Mr. Pappas, what would you like me to know?
I think Dan has it pretty well communicated in the report he made. Pretty much put everything out there for him to know, so I don't think there's anything else.
Well, there's a couple things. You were on bond on a domestic violence charge at the time you got arrested for this. You were placed on bond for domestic violence on October 5th. There was a condition of your bond that you're not to drink any alcohol. So you were in clear violation of your bond conditions on a domestic violence charge. You're also not to have any contact with a complaining witness. But I think you and she may have seen each other earlier that day. Did you see her on the day of your arrest?
She was incarcerated at the time.
Well, not sure what day she got picked up. On 10/18, Mr. Pappas worked from 6 to 4, went home. His girlfriend had been arrested, was facing a few felony charges. So where was she in jail?
She was here in St. Joseph. She was the day the charge I got for the domestic was that happened the day that she went to jail. We got in an argument. I was attacked by her dog, went to the hospital.
Yeah, but they ended up reducing that to a disturbing the peace.
Yes.
But that was October 5th. This one was October 18th.
She was arrested October 5th and was released, I believe, the 22nd.
All right. So you didn't have contact with her. October 18th is a Saturday. Now I'm a little confused because you were drinking at home. You went to Applebee's and had a Long Island iced tea. Now you got out of work, you said at 4. So everything happened between 4, the time you got arrested, at about 10 o'clock. So that happened in that 6 hours. You drank a Long Island iced tea. We talked about this morning. People don't drink Long Island iced teas because they think they really taste good. They drink them because they have a lot of alcohol in them. So the problem is you left Applebee's and then you were headed back to Applebee's. And so I'm a little confused. Another officer, I wasn't clear whether he was in his patrol car or his private car.
I can help you there a little bit. I wasn't going back to Applebee's. I was trying to leave Applebee's, and when I made the turn out of the drive, I turned back into the grass over the curb.
All right, here's what, maybe that's where I'm misreading it. On this day, I was traveling westbound on Broadway Street from 130 Run. I observed a blue passenger vehicle fail to stop before exiting the private drive of Applebee's. The vehicle made a wide turn onto westbound Broadway Street without yielding. The vehicle continued turning left, hopping the curb on the south side of the road and continued over the sidewalk. Then traveled down a small hill adjacent to Applebee's parking lot, eventually coming to a stop in the grassy lot just west of Applebee's. So you actually went out into Broadway and then like did a loop and then back into.
I believe I came out and made a turn and just kept continuing the turn up over the curb.
Well, Applebee's shouldn't have ever let you drive away from there. But fortunately, you didn't kill yourself or somebody else. You're a .222. A little while later, the intoxicator's less than that, but nonetheless, you got this generous plea offer of the reduction to impaired. You got a lot of baggage on your driving record, and alcohol hits a lot of the same addiction reception as heroin.
Not initially, I did not, I think when we were speaking about it, but I saw that it got resolved with a, disturbing the peace charge.
It
And
did,
I had
but he,
assumed that the bond issue had gotten addressed at that final plea, I was assuming.
no, it didn't. Judge Pattison did it. I don't think he knew about it.
Oh, okay.
All right, tell me about Boma Benton, where you work,
They're a contractor out of Portage.
and what do they do?
We do metal framing, drywall hanging, drywall finishing, acoustical ceilings, painting, vinyl hanging, and
Daniel, have we confirmed that he actually works there?
No, I did not confirm that, Your Honor. I don't usually confirm that until they're actually placed on probation, usually.
So are you on a layoff status or are you actually working on projects?
no, I work every day.
You also smoke marijuana. And so a very high percentage, I think, of our drunk driving cases also have THC in their system. We just don't know. There isn't a good way to test for it. But anecdotally, many people, if I give you a test today, would it have marijuana in it?
I believe it would.
All right, you have to deal with that also. Do you have a medical card?
I do, but I believe it's expired.
And as Miss Camfield stated, you also had a 25-ounce can of Budweiser. That was, of course, it was October, but it was still cold. Like I said, Applebee's probably shouldn't have let you leave. All right, Daniel, you have recommended some additional jail. My inclination was to put him in jail right now for the bond violation, but I don't want him to lose his job. Anything else you want me to know?
No, but that is one of the reasons why I considered the 2 extra days. When you put it all
Well, he's
together.
still smoking weed.
Well, he
which
said
is-
he stopped a couple of weeks ago, and with the problem with the high B8 or the high THC and a lot of the stuff kids are smoking, or kids, I'm so old. People are smoking nowadays. It stays in their system a while, so I figured we'd test him right away and see where he's at and kind of get a handle of it that
Well,
way.
it's lawful for adults to use marijuana for recreational purposes. But if you're on a bond or a probation, generally you can't use it.
And I was going to have him start testing like once a week for starters.
All right. Are you doing any support group, AA or Celebrate or anything?
I had my first evaluation at Pivotal yesterday. I go back the 5th of March for another one, and I have not participated in any AA meetings yet.
When you were struggling previously, did you ever do any NA?
I did when I was in county jail. I spent some time in Porter County Jail, Indiana for quite a while. That's where I completed the CDA program they have.
Right now, you're just holding your breath. Your testimony is, or statement, you haven't had anything to drink since October. Maybe they gave you this because you got a job. If you got an OUIL, you'd lose your ability to drive, and you couldn't get from Three Rivers to Kalamazoo, where your work is. Where's your significant other? Is she still in jail, or she
was released.
Has she been sentenced yet?
Yes, the felonies that she had received were dropped, and she pled out to a misdemeanor.
All right, so is she back as part of your life?
Yes.
Do you still have the dog?
Yes.
All right, Daniel, I'm gonna follow your recommendation. If he blows it, I guess we can always amend it. 24 months, which could be done at the end of 12 months. However, 7 days jail credit. 2 of the 7 days, 3 are deferred. You owe a couple days for this and for doing this while you're on a bond with no alcohol. The probation department arranged that. No drugs and no alcohol. Test as directed. The victim impact panel. No police reimbursement. I told the chief, you guys keep dropping the ball on that. Do you have one in your file, Angelique?
I do not, Your Honor.
Substance abuse counseling and treatment as directed. All right, carries $300 fine, $75 crime victims' rights fee, and a $50 state minimum fee, $100 screening fee, $150 attorney fee, $960 probation oversight fee. If you do this in a year, it will save you $480. The victim impact time was 32. I'm gonna not do a police reimbursement. If they're gonna submit it, I'm not gonna stick the people with it. Even though there was a 300 plus 125 in state costs plus $100 screening fee, $150 attorney fee, $960 probation oversight fee, and a $32 victim impact panel is $1,657. There is no bond. This really is a pretty good plea offer to impaired. You were very drunk, you were dangerous, you had a very high blood alcohol level, you got a lot of criminal baggage, but this will allow you to keep your job. Not to use any drugs or any alcohol, including marijuana. We're going to get you at a clean status. And if you can just keep holding your breath, then you're unrealistic. You need some support group. Daniel, do you want to see him in the breakout room or just have me send him out to the counter?
I will call him, or he can call me when he gets done with the counter.
All right, maybe we'll make this work. Dan, I want to confirm his employment also. Make sure I'm not ghosted.
We'll do your.
We're gonna get a test. See what's in your system. They might even do that today, but Daniel will discuss that. You're not gonna get bounced if you come back with marijuana in your system today. We're gonna see what your levels are. And we'll see where we go from there. 6-2. All right, if you take him out to the counter. Mr. Gibson, we've got a question. I'll be with you in a minute, Casey. We're set for next Wednesday for a jury trial with Mr. Christopher Pontius. And it's a no insurance and unregistered vehicle. Prosecutor made a plea offer. Mr. Pontius declined it. He originally appointed to represent him, but his representation was he wanted to represent himself. Somehow it was on Judge Pattison, then it got assigned to me. I don't believe that you're counsel of record in this case. We sent him some stuff and it came back. Do you know if he's even on your caseload? Is he set for on your calendar for next Wednesday?
Well, I had him on my calendar. I noticed that, I think it was yesterday, and so I sent a question to the clerk's office asking them if I could, take that off of my calendar or whether I was still on that case. So they said that I was no longer on that case.
I believe that's the status of it. He was emphatic. He wanted to represent himself.
But the day still looks open.
Does he, well, we won't be able to do a trial that day. And so we were working on the cases that were there. I don't know whether he even has notice of it because we sent him some stuff and it came back. Ms. Camfield, your office hasn't had any contact with him?
The last communication I see in the file would have been a discussion apparently had on November 6th, and that might have been when he still had counsel.
That was the last pretrial.
So I have not seen anything since, at least it's not in the file noted.
I could always check to see if
well, if we have contact with him, we need to let him know the case isn't going to go that day. Angelique, have you had any luck on the other two cases that are set for that day? One is Luke's and one is.
I don't know yet, Your Honor, because I've been
busy
dealing with other matters.
All right. Anyway, I sent some email either last week or earlier this week, and I know Tim was working on it. All right. If anybody knows Mr. Pontius, tell him to contact the court because his case isn't going to go on March 4th. All right. Thank you, Paul.
Thank you.
All right. Our next matter is.
Real quick before we get to the next matter, we will be ending today at the top of the hour here. We're going to cut it an hour short today. I told you as Mrs. TCF works through rehab and whatnot, physical therapy, that there are other things that are, still have to be tended to, so we have to kind of adjust the schedule around and whatnot. And today is one of those days, so an hour short today, so we can accommodate her PT plus other things we need to do.
Matter was set for sentencing today. Ms. Walton has prepared the screening report. And Ms. Strong, I know you're on top of this. What would you like us to know?
Thank you, Your Honor. Ms. Horton, I would first like to thank probation for the report they put together. Ms. Horton is 22 years of age. She does reside out of the county, but is more than willing to come back into the county for any kind of probation. The facts of this case were not good. And I'm going to say that before the prosecutor does, because Ms. Yep.
She may use different terminology, but I think we're in the same ballpark.
But the point is that Ms. Horton understands that. She appeared at the time of the attorney pretrial and took responsibility and took the offer. She has engaged with some AA classes prior to this. She's been working on a substance abuse assessment. She's remorseful about what happened and ready to take responsibility. I would ask, in looking at the recommendation, I see that there is 1 day to serve on a weekend. Ms. Horton does have children, so if the court imposes that consequence, I would ask that it be scheduled and or lumped in with the deferred days. And I would also ask that one of the probation goals be that the probation officer helps Ms. Horton achieve her GED. She did not receive her diploma and she left at the time of 10th grade.
All right, Ms. Canfield.
Well, Ms. Strong is absolutely correct that this was a very serious accident. And if I may have the court review some photographs that have already previously been electronically provided to the defense, and then I did allow them to see this morning. That's just an oversight of the accident. You can see it was a clear, dry evening. There were some slight yaw marks indicating that maybe she did try to brake, but she went off across a yard. And thankfully, the tree was small enough that she snapped it and continued on rather than killing herself, crashing into a larger tree. She just missed a huge landscaping boulder, but then eventually went through another smaller garden and ended up in their porch. She did injure herself in the accident. You can see from the photographs that the airbags also deployed when she struck at the tree and then subsequently the porch. So it was very serious with the blood alcohol of a 0.204. It's also extremely concerning at her young age, and at least explanation that she's given to probation that she doesn't drink very often, but every time she does drink, she drinks to excess. And her intention is to get drunk. That concerns me. And I disagree with, maybe the members at the AA meetings where she has attended have a more significant problem with alcohol, but I still believe that she does if the intention each time of consuming is to actually get to intoxication. And even more concerning here was her response to her employer that, yes, I'll come into work at that intoxication level.
Well, yeah, she was going to work.
Yes, yes.
I have a guy in sobriety court right now. He was a mailman and he was on duty as a mail carrier with a 0.20 blood alcohol level. And we've had some other people that were, this just makes the hair on the back of my neck stand up.
It does.
And then she says, I don't really drink very much, but when I do, you drink a lot to get a tolerance to get that drunk and then go to work. Oh my gosh,
And
maybe
so,
you would have lost your job, I think, if you'd shown up that drunk.
I think the positives here are that she's recognized it, she's taken responsibility, she's looking to better herself and deal with it, although I think there's still some denial as to the seriousness of the issue. With her being employed and having young children, it's alarming. I don't know, hopefully she's not drinking at home around the children. But in this particular circumstance, this is one of those cases in which I would recommend straight up front jail. It's hard for me in these circumstances to say that deferred jail is appropriate, because frankly, when they're placed on probation, any jail is going to be deferred if they violate. But in this circumstance, with the severity of the accident, thank heavens, nobody was in that yard and no one was on that porch that could have been killed.
Well, let me ask this, Ms. Horton. Where did you start this journey? In Edwardsburg?
Yes.
So you made it all the way from Edwardsburg to there where you had the crash?
Yes.
Were you drinking on the way?
No.
Which way did you come from Edwardsburg?
I was in Edwardsburg and I came down 12.
Okay, then Fawn River.
And
that's okay. All right, I'll give you a chance to tell me more when I hear from the others. All right.
Thank you, Honor. She had indicated to the police officer that she had begun drinking in the afternoon and had quite a number, 5 to 6 full-size drinks, a normal cup size, she said, of New Amsterdam vodka mixed with Dr. Pepper.
Well, I think I have to call that something. I'm not sure what you call that.
She referred to them as twisted teas.
I think twisted teas were also in addition to that.
She had
That's-
smoked marijuana the night prior, which was also in her system. I do note that there was a sedative in the system, but I believe that was administered at the hospital or in the ambulance on the way to for pain medication prior to the blood being drawn. So I don't think she partook of that prior to the accident, but I am very concerned about polysubstance use here in somebody that young and arising to this level to result in the severity of the accident that did occur. She is so lucky that she didn't hit one of the larger trees in that yard and kill herself. I mean, it is very, very serious. And then her children would be without a mother.
And her license was expired. There's more going on here, Miss Horton. This is so very self-destructive. This is, you're punishing yourself. There's some underlying issues we need to get a handle on. And I don't want you to smoke marijuana. If you're gonna get a medical marijuana card, I might as well just put you in jail right now. I'm not gonna let you trade alcohol for marijuana. You're old enough to to smoke marijuana, but it's a condition of probation that you not use it.
I won't, but it was for my heart condition. It wasn't, I have a severe heart condition. It wasn't for.
I would be surprised if your cardiologist prescribes marijuana for your heart condition. Maybe a marijuana doctor might say it cures migraines, ingrained toenail, and heart condition, ingrown toenail. But a cardiologist isn't going to tell you to smoke marijuana as part of your heart regimen. Maybe it helps you sleep, maybe otherwise, but you're not gonna, if you're gonna do it, I might as well just put you in jail, get it over with. Then you can smoke all the recreational or medical marijuana you want. But we got issues we need to deal with. As she indicated, this was bad. Now, the other guy, he got an impaired. He got a bunch of criminal history, but it was his first drinking driving. His blood alcohol was close to what yours was. And he ended up on the lawn in front of Applebee's after drinking Long Island iced teas. He got a sweet deal. Yours, they stopped at operating while intoxicated, which I understand because you got this dramatic accident in these people's front yard. But this is going to prohibit you from driving. He got a restricted license. What's that going to do to your employment?
I get drove to work every day.
Somebody takes you to work every day?
Yeah, and somebody drove me here. I understand.
Who drives you to work?
My boyfriend or my job comes and gets me.
All right, very good. Who watches your kids while you're at work?
My grandma.
You've also got a foot injury. Tell me about that.
In the accident, my ankle went out of the front of it. So it went through the skin and I shattered my entire ankle. So I have plates and screws throughout my ankle. So I will never walk again the same again. And I will have to go through several different surgeries for it. And because of it, it has put a strain in my knees. So this whole leg doesn't work the same as it used to. I understand how serious the accident was.
Well, that's a permanent reminder of a temporary feeling. You're gonna carry that for the rest of your life. Priscilla is a longtime clerk in probation, but new as a probation agent. And Priscilla, this is gonna be a probation that's gonna need some supervision. What else would you like to add, if anything?
I agree with Ms. Canfield. This was a very serious accident. At the time of the screening, I don't think I was aware as to how severe it was being noted from Ms. Horton. She did tell me that she broke her ankle. After I spoke with Ms. Horton and I reviewed the police report, I saw how severe this accident really was. Like Ms. Canfield said, she injured herself, but she could have injured someone else, it's almost a 40-minute drive from Edwardsburg to her job. She's very lucky that she did not cause an accident or kill someone on her way. I mean, she caused an accident to herself, but she didn't kill someone on the way here. I do think at least a day in jail is warranted. I understand that Ms. Horton has kids, but we need to protect, the people in our society. And I know she learned I hope she learned her lesson by this injury that she attained from this accident. But I do think some jail is warranted, and 24-month probation for her to watch the victim impact panel as well. And I agree that Ms. Campbell said, yes, Ms. Horton stated that she took some AA courses, and the people there may not believe she has an issue with alcohol, but it takes a lot to get to a 0.204 and to think it's okay to drive to work.
Well, we need some treatment. Something is going on for a 22-year-old girl to get this drunk in the middle of the day and go to work. What I find is there's unaddressed trauma, childhood trauma or otherwise, in your background, which is causing you to drink like this to kill the pain. And it's a big pink elephant in the room, and I'm not going to ignore it. It's the main thing we need to address. I could just give you 16 days in jail and call it good, and you could go on with your life after that. But there's a reason why you're doing this.
Your Honor, I should also note, when I review the laboratory report for the marijuana that was found as well, the Delta 9 THC level was 17 nanograms per ml, which is not a metabolite. That's an active psychoactive substance. I've spoken with the lab scientists about these particular results. It certainly is indicative to me that it wasn't smoked the night prior, as she had indicated.
Either way, as I said on our last case, a high percentage of our drinking driving cases have marijuana also in the picture. It's lawful, and it's hard to tell. If you smoked marijuana 3 days ago, this guy was drinking Long Island iced teas, it might still show up in his system. But I'm going to do a 24-month probation. I'm going to do 16 days, credit 0, giving 16 days to serve. Of the 16, 14 are deferred. You're going to do a whole weekend in jail. Probation department will arrange that, and you'll have to arrange for childcare. Also, this is money away from you and your family. $300 fine, $75 crime victims' rights fee, and a $50 state minimum fee. $100 screening fee, $150 attorney fee, $960 probation oversight fee, and you can do this in a year, which would save you $480. The sheriff's department did request a restitution, $255. And the victim impact panel. You might someday be a speaker at the victim impact panel. How you almost killed yourself. I'm also recommending substance abuse counseling and treatment, either through Cass County Services or ours, but I want to get a handle on why you're doing this to yourself. Not to drink any alcohol or use any controlled substance, or attend the victim impact panel, or your test as directed. If we gave you a test today, would there be marijuana in it still?
Yes.
All right, well, you're gonna have to get that to 0.
Yes.
I'm surprised that your employer doesn't test for that. If you're doing home health care, you don't have to test for work?
No.
You seem like a nice young woman trying to make your way in the world. You can save yourself a whole lot of grief if we could get a handle on this issue now. How many children do you have?
Two, one's adopted.
All right, so you have one child that you're responsible for?
Two,
Two, okay. Are the child's parents, the dad's involved?
no,
So you're a single mom, living with your grandma. Do you get child support or anything?
no.
All right, you got a lot on your young plate. I'm serious. You could have a whole different course of life if we get a handle on this now. Otherwise, it's gonna be a long, bumpy ride. All right. And if I put you in jail for 16 days, people will say, you should have thrown a book at it, blah, blah, blah. I don't know what I accomplished. You lose your job. Do they know about this?
Yes,
All right. Did they do any employee counseling or anything?
no,
Now, I'm gonna guess at some stuff. You didn't think you were gonna go to work that day, is that correct?
no, it was my day off.
So you got drunk because it was your day off, and then they called you up and said, hey, can you come into work?
I had a few friends over, and then I got called, and then, yeah,
And you didn't want to let them down, so you showed up for work anyway.
yeah,
Well, it all caught up with you. You're in Edwardsburg,
yes,
but you work over here. I'm not gonna transfer your case to Cass County. They got good people over there, but so do I. And I want to stay on top of this myself. So we're gonna do your probation here. All right, you go with Priscilla. And
Thank you, Honor.
she will get you started.
All right, friends, that does it for today. I hope you guys enjoyed the show. I enjoyed bringing it to you. We'll be back tonight over at In the Blind, 7 p.m. Eastern, 4 p.m. Pacific. That's assuming Michael doesn't have something crazy go on at his appointment, which he's at right now. But look forward to seeing you there. And we'll be back here tomorrow morning on this channel, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Go have yourselves a great Wednesday. We'll see you soon. Take care. God bless.